Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3177, United States of America versus Frederick Gooding, appellant. Mr. Flannery for the appellant, Mr. Lieberman for the appellee.
Good morning, counsel.
Morning. Good morning, Your Honor. It's my honor and privilege to represent Dr. Gooding, a man whose only offense was to try to treat his patients, seniors who, like many patients across America, are the collateral damage of a DEA policy to shut down all doctors who give pain medications more than a Tylenol. The first proposition that we raised in our brief on appeal was judicial bias, that we are entitled to an impartial tribunal, and in this case, we did not have one. We did not have one for the end of the first case that resulted in a mistrial, and we certainly did not have one on the second trial. I do not say that this was done with any malice aforethought. We found out about it only because of the admission by the judge who is well regarded and well respected, who honestly expressed her opinions. Now, in 28 USC 455A, it provides that we can challenge and look for the impartiality that might reasonably be questioned. We have that here. There is a second provision in the code, 455B, which talks about personal bias or prejudice. The government, in its brief, my colleague, cites an affidavit that is connected to that second prong, personal bias or prejudice, rather than her impartiality might reasonably be questioned. 28 U.S. Code, Section 144.
Did you raise this issue below?
Yes.
You raised it before the.
No, we did not raise it below, Your Honor, because we found out about it after a year of this bias being concealed from the.
Did you find out about while you were still in district court?
I'm sorry, I didn't hear you.
Were you still in the district court when you found out about it?
After sentencing, yes.
Okay. Why didn't you raise it in the district court?
Because it would have been futile.
Why?
Because all the damage had already been done. Her removal from the case at that point would not have solved any of the problems of her prejudice in the case. In fact, her original decision.
So her removal will not resolve your bias claim. Is that what you said? You just said that her removal would not solve your bias claim?
No, because the bias had already done its damage.
Well, normally what happens if you actually have a bias claim is that there'd have to be a new trial.
Well, I think when a court says that it doesn't trust the word that you say, you are not entirely candid. I do not believe you told the truth on the stand. And when you say that just before a mistrial in the first trial, and you go through a whole second trial and you make this.
That's not a question I asked you. I'm asking you, you're supposed to raise these issues. You're not supposed to save them for appeal.
Well, there is no requirement for a waiver as to the first prong of 455A, which says her impartial.
Our precedent says if you don't raise it in a timely manner before the district court, even though you knew about it, you have waived the argument.
Well, first of all, it couldn't be timely because it had been concealed for more than a year. Since September of 2000.
It's timely if you become aware of it while you're in the district court.
You become aware of it and the case is over. The case has ended. There is nothing for the judge to do.
You can ask for reconsideration.
But there is no debate about the words. And 28 USC 144 speaks of raising.
Have you looked at precedent on this issue?
I think the statute is sufficient, and yes, the precedents.
I'm sorry, is our precedent not relevant to this issue? Is that your position?
My position is that the cases that cite 28 U.S. Section 144 are limited to the question of personal bias or prejudice, which is 28 USC 455B. And
your position is you just can raise this for the first time on appeal. I just want to understand your position.
My position is we first knew about it at the end of the case in the district court.
That's a factual answer. I'm asking you what your legal position is.
My legal position is we raised it on appeal.
Stop. Don't interrupt. So please explain to me what your legal position is on when these can first be raised.
We raised it on appeal.
and you don't have any obligation, would you have any obligation to raise it in district court if you learned about it?
Not on the
Trial.
circumstances of this case.
No, it's not what I'm asking for a legal position. You want us to write an opinion.
Well, you just asked me a
Excuse
question.
me. Is your position that had you learned about this mid-trial, on the second trial, that you still, given the statute's words, would not have to raise it on appeal, until appeal?
I would have raised it during the
I'm asking
trial
you
if
what
I
your
knew about it.
legal position is, though. You just said the statute doesn't seem to require you to raise it in the district court.
No, what I said was the statute does not require an affidavit except if you're invoking 28 USC 455B, which involves personal bias or prejudice. And the affidavit mentioned in 28 USC 144 is an affidavit limited to that question, personal bias or prejudice. And in that circumstances, and only in that circumstance, in any authority I can find, is the only case in which an affidavit is considered. And an affidavit does not have to be presented before the term date, and for good cause, it can be ignored. It can be overlooked. You don't have to file an affidavit even as to the prong B, personal bias or prejudice. How is one, and as an example of what went wrong here is we have the court on the one hand saying that the similar act out of a Delaware administrative proceeding doesn't apply. That is her statement, the court's statement on August the 8th, 2022. And then my client's testimony is on September 12th, 2022. And after that date, then we see these rulings that are consistent with this bias that she expressed only a year later toward the end of the second case after the sentencing.
So what our,
Yes, sir.
what our precedent says is to raise this exact type of claim, you have to raise it, quote, within a reasonable time after the grounds for recusal are known. So I think kind of the straightforward question is, why couldn't you have raised this during the sentencing hearing or at a reasonable time after the sentencing hearing? That would allow the district court to respond, to build a record, and then it goes up on appeal. And that's what our cases say is required.
Well, but we raised it within literally days after we knew about it in the appeal.
Right.
And the argument that you're making to me is that we can have a biased tribunal, but procedurally we can protect that bias should it not be raised then, when it would be a futile exercise given the fact that the prejudice had existed for more than a year in the trial court to the disadvantage of my client who's entitled to an impartial tribunal, which he did not have.
So it's not an argument. It's just we as a panel are bound by our precedent. So it seems to me it's very straightforward that a motion could have been filed after the sentencing hearing in the district court. So is there anything you can tell us about why it was impossible, for example, for you to do that?
Impossible.
You think it would have been futile? I mean, I think if
Well,
anyone
I
who
don't-
thinks the judge is biased against them probably thinks a recusal motion is biased.
I think this,
It's futile.
sorry, sir.
Yeah, go ahead.
I think this circuit, forgive me too much New York. I think this circuit has only expressed this view about an affidavit and when it's raised in the question of personal bias or prejudice, which is prong 455B. That's my position. And I understand what you're saying, that you have said if you don't raise a question and don't object and so forth. Okay. But I found no cases in which a judge had admitted to a bias more than a year after two cases had concluded and admitted that she believed that my client was not entirely candid and so forth, and that her opinions in the case changed after that. Rarely do we see an expression of bias so clear and so evident by a jurist. And I'm talking about a lifetime of seeing judges say, oh, I said that, I shouldn't have said that, and reacting to it.
Can you explain why this was so out of bounds? It seems to me that at sentencing, it is fairly commonplace for judges to comment on how forthcoming they think the defendant was and how candid they were during the trial.
Well, I'll give you an example. In August 8th, 2022, the court said that it thought that the similar act, so alleged, out of Delaware was an act that could be considered too prejudicial, involved malpractice, negligence, that it had no bearing on this case unless at any time it could be presented that the implication of knowledge was necessary as a result of that earlier proceeding. After that, the judge heard my client's testimony at the first trial, and her judgment changed. Now, people can have biases. The court had a bias. The court made reference to the family's experience in the medical profession and suggested that that was a reason. The judge said we would not consider, if you will, malpractice elements in the case. Well, and the malpractice elements in the case were raised as a result of this earlier proceeding, never permitted to be considered by the court. So the court said, but then they were. There were no instructions to the jury as to how to handle them. And in the case, we had 2 barrels of information. One barrel was excluded from anything having to do with ultrasound. The other barrel only mentioned the questions of fluoroscopy and CT as imaging devices. What the government did was they only looked at those codes that involve fluoroscopy and claimed, see all of this, ignoring the fact that was disclosed and not deceived was in every instance we can find, and it's spelled out in our brief, in every instance we can find, the government was informed, that is, Medicare was informed of my client's use of ultrasound codes that were recognized by
Thank you very much, counsel. Your time is up.
Thank you, Your Honor.
My understanding is you did not wish to have any time for rebuttal. Is that correct?
If I could have 2 minutes, I would appreciate it.
Okay, because you told the clerk you didn't want any time for rebuttal?
No, I didn't expect to spend so much time enjoying our discussion about the first issue.
Okay. Here from the United States now.
Good morning, Your Honors. May it please the court. Dave Lieberman for the United States. Turning to the judicial bias argument, I think from the court's questions, the court understands the government's position. We read this court's precedents to say that a litigant asserting a judicial bias claim must raise it first in district court. That's the Bryce case that we cited. Bryce cites a previous case, Barrett, that I think has the exact factual circumstance at issue here, raised for the first time on appeal. Alternatively, we think that the district court here, Judge Chutkin, for the reasons expressed by Judge Garcia, it was permissible for the judge to consider a defendant's obstructive conduct during the course of the proceeding. We've cited a number of circuit cases, including this court's decision in the ransom case, and we've also cited the Supreme Court's decision in Latecki, which makes clear, in our view, that events that happen inside the courtroom, inside the proceeding that a judge observes and rules on is not ordinarily grounds for judicial bias, absent a showing of deep-seated antagonism, and the record does not show that here. I just wanted to flag at least a different recollection of the timeline than my opposing counsel as to the first trial, as to when the judge made certain rulings. As I understand the record, on day 4, government supplemental appendix 40 and 41, this is where Judge Chutkin concluded that issues of Dr. Gooding's knowledge were in play and therefore authorized the admission of the redacted Delaware Medical Board order. And then by my recollection at the first trial, Dr. Gooding testified subsequent to that. So I think she issued her ruling before the defendant testified. So I don't see how that possibly evidences her bias. Mr. Flannery referenced some comments by the district court regarding the prejudicial nature of the redacted Delaware Medical Board order as evidencing her initial position. If I could provide some context, these were in the reply brief at pages 16 and 17. The court made those comments at the pretrial conference before the first trial. And the court was looking at the unredacted, extensive detail on Dr. Gooding's actions with respect to the patient in that case, and made a number of findings unrelated to the fluoroscopy requirement that I think everybody in the courtroom agreed could not come in this case. These were the findings of negligence and certain things that Dr. Gooding failed to do after the patient deteriorated in his office, lack of training, lack of records. We can provide the court with a copy of the unredacted order if you would like to see what Judge Chutkan was looking at when she made those comments. It is later at the pretrial, on day 4, Judge Chutkan supervises the extensive redaction of the medical board order, which you have in the government supplemental appendix, to remove all of these collateral matters. And she finds that these redactions are sufficient to remove her concerns, her initial concerns about prejudice. I have no further comments unless the court has any questions about the judicial bias issue. I wanted
to ask you about the 404 issue about the omission of this medical board.
Yes, Your Honor.
Or the redacted version of the medical board order. That involved different procedures. The conduct at issue was 8 years before the conduct at issue in this case. And it had nothing to do with how things were billed to Medicare or knowledge of what Medicare required or standards that it required. It dealt only with Delaware standards of care. So how under McGill and other precedents was that report not too stale in time, and its conduct, the conduct that it addressed, too far afield to outweigh the prejudice and the prejudice balance?
So let me take the staleness issue first, and then I'll go to the second part of your question. As to the staleness, it was a 2009 medical board order, but the restrictions in Delaware continued on for multiple years afterwards. It was also, that order was...
But you're admitting it for the conduct, and you're trying to show knowledge about conduct. The fact that he had a suspension in Delaware isn't the conduct that you're trying to admit. You wanted to admit, and what you admitted into evidence was that he had performed these procedures without fluoroscopy or CT, but they were different procedures, but he had performed them without those technological supports. That time gap between when he performed those without technological support and when he performed the procedures at issue here without the procedures that Medicare requires was at least 8 years.
So I think the times
Yes?
of...
No?
Yes,
Okay.
but...
And that's way too long under McGill.
So I would ask the court to take a look at both the results of the Delaware Medical Board order.
I have looked at it.
Yes, and the instructions about the standard of care and the probationary period continue for multiple years beyond 2009. And the same restrictions were adopted by the DC Medical Board and went up to 2014, which is a year before this scheme started.
Were you admitting the report to show the length of his sanctions or to show that he had engaged in similar conduct?
To show his knowledge of the fluoroscopy requirement.
Okay, well then, his failure to comply with the requirements, his knowledge of it, but that was, so you're saying that would have been at least when the board issued its decision in 2010. So you're still dealing with a 5-year period.
I think that's right, but the fact that the board had sort of put on probationary periods and it was going to continue to monitor him for compliance with the instructions regarding the standard of care, specifically the fluoroscopy requirement, the fact that the DC Medical Board incorporates the same up through 2014 gets us right to the doorstep of the conduct at issue here. So we think it...
And also that conduct was failure to comply with, I guess, Delaware's medical standards. But that's not, this case is about fraudulent filings with Medicare, which seems to me, I mean, I don't know how, even if I give you the time gap, his knowledge of what Delaware required as a standard of care informs what Medicare is going to require for billing.
So 2 responses to that, Your Honor. First, the scheme that we charged, this is paragraph 17 of the indictment. We alleged he submitted false and fraudulent claims for services that he knew were not medically necessary. That's the Medicare standard. And so evidence that he had been informed of the standard of care in Delaware and that the DC Medical Board subsequently adopted.
So that might be, sorry, just to interrupt, because
Yes.
this might be the gap in my understanding. When the DC Board opposed reciprocal discipline, which we do all the time as to attorneys, does that mean that DC has this, does that show that DC just does reciprocal discipline, or does it have the exact same standard of care on this very issue?
I honestly don't know the details of the
If it
DC.
doesn't show that, then I know he
So,
wasn't doing the standard of care in DC when he did these procedures and yet was filing with Medicare.
So-
That would be.
so if I'm recalling the record correctly, the DC medical proceedings, I think they were started by this reciprocity that Your Honor is talking about, but Dr. Gooding did not contest the ability or the decision of the DC Board to basically adopt the same probationary terms
That's
as,
different than saying adopting the same standard of medical care in DC. I mean, maybe this is a universal standard of care. I don't have any idea, but there's, at least I haven't seen record evidence about that.
so we also had a medical expert essentially testify that this is the standard of care everywhere. And the other point that I
And
want,
that's the theory. That's the kind of
Yes.
theory that it wasn't just that it was a reciprocal probation, but he knew when he set foot in DC and did procedures here, that at least for some forms of spinal injections, he had to do a fluoroscopy or CT to comply with the standard of care.
that's the connection, Your Honor. And a second basis is the defendant, Dr. Gooding, offered a good faith defense at trial. And if you look at, this is in his closing argument, where counsel talked about Dr. Gooding was doing what is best for his patient population. He's treating them how he knows best. And he argues that all of this defeats the government's claim of intent to deceive, intent to defraud.
Part of his argument is that I filled out forms where I told Medicare exactly what I was doing. There was some special billing form that indicated he was doing it with ultrasound. Why does Medicare allow billing codes that it doesn't compensate for?
So the testimony at trial was that the billing codes it's medical codes not created by Medicare, but by the American Medical Association. And that the codes that the defense was referencing, the T codes, are for experimental, unapproved procedures. But they still get codes because it's a record keeping point, but there was unchallenged testimony that Medicare does not provide reimbursement for T codes. Your Honor also your first question asked about that these were different procedures. I just want to respond to that. So the Delaware procedure was a cervical spinal injection, so at the top of the spine. The procedures discussed at trial were in the lower portions of the spine. And Dr. Gooding, in his reply brief to this court, has argued that these were different procedures, couldn't possibly show knowledge. That argument has been raised for the first time in the reply brief. It's not in the opening brief, where the 404B claim is at pages 48 through 53. So in our view, this claim has been abandoned or forfeited for
Did
appeal.
he raise that point in district court in opposing the admission of the records?
No, Your Honor. So district court docket number 42, his motion in limine, that was before the first trial. His district court docket number 100, that's in advance of the second trial. There's no message of this distinction claiming a difference between injections at the top of the spine versus injections at a lower portion of the spine. In fact,
He admitted knowledge of what was required, did he not?
absolutely. And in the defense motion in limine, before the first trial, district court docket number 42, page 4, the only mention of this actually goes in the opposite direction. The defense motion talks about the Delaware procedures and then makes reference to, quote, the similar medical procedures in this case. That happened again this is separate and apart from admissibility, but this happened again with Dr. Gooding's own trial testimony in the first trial. He talks on direct about the dangers of cervical spinal injections. On cross-examination, my colleague asked him about the medical board. He acknowledged standard of care, the fluoroscopy requirement with respect to cervical injections. The trial transcript, district court document number 90, transcript pages 976, 977. My trial colleague then asked about the facet joint injections in this case. This is a direct question to Dr. Gooding. Is it fair to say that the procedure is virtually the same procedure, just in different parts of the spine, the cervical spine, the thoracic spine, the lumbar spine? You agree with that? Answer from Dr. Gooding, yes. And so just compiling all of the information before the district court in terms of what was raised, what was not raised in the motions in limine and our responses, the district court had no notice that there was any dispute that these were different spinal procedures, such that evidence of knowledge with respect to the fluoroscopy requirement as to the procedures at the top of the spine did not extend to Dr. Gooding's knowledge of the requirement and into lower portions of the spine. Unless the court has any other questions about this or any additional claims, the government asks that the court affirm.
Thank you.
Thank
very
you.
much. All right, Mr. Flannery, we'll give you the 2 minutes you requested.
Thank you, Your Honor. The Delaware proceeding referred to any performance of cervical and paracervical injections. It's in our brief at page 12, our opening brief, and cites the indictment at page 3, paragraph 11, and it's in the appendix at page 3. The government, however, talks about spinal injections instead of paracervical. The significance is the difference in the bone structure and how much more care must be administered when dealing with the upper region of the spine as opposed to the lumbar and sacral sections of the spine.
Was this, they just explained that this distinction was not raised before the district court when the issue of admitting the Delaware report came up in either case.
It was argued. It was argued because of the distinction, and the argument was
Do you have
frequently
a
made.
record citation?
As I stand, no, but I can supply it, Your Honor. The argument in the trial was very much about two things, I would say. One is that the codes that my client used were disclosed to Medicare. So it was a question, it wasn't a question of deception. It was a question of disclosure. They had the disclosure. But in the arguments made in the case, we only talked about those codes that the government chose to focus on, that they said were violative, and that could not be said because he should know that it can only be done with fluoroscopy or CT. The AMA codes, which provided for ultrasound, not only were in the code book for all the years that are relevant to the charged indictment, but also they were charged, and the government says, we presume the honesty of our providers. Now, while that may be what they say, the evidence is that for everybody, both my client and the peers that they used, that they were permitted to both submit requests, and those requests by my client and others, and my client included the ultrasound codes, the AMA codes, that they granted money for it. And first they said it could be.
I think we have that from that argument.
You have that in my brief, yes.
All right, thank you. The case is submitted.
Thank you, Your Honor. Thank you, panel.
Case number 23-5110. People for the Ethical Treatment of Animals et al. Appellants versus Lawrence A. Tabak in his official capacity as Acting Director of the National Institutes of Health, and Xavier Becerra in his official capacity as Secretary of the U.S. Department of Health and Human Services. Ms. Krantz for the appellants, Ms. Utrecht for the appellees.
Good morning, Ms. Grant.
Good morning, Your Honors, and may it please the court. My name is Stephanie Krent, and I represent the plaintiff appellants. This case is about a government agency's decision to ban criticism of its policies in otherwise open comment threads on the agency's social media pages. The NIH uses keyword blocking on Facebook and Instagram, which functions as a prior restraint on all comments that contain the words and phrases of the agency's choosing. Here, without informing the public, the NIH has chosen to censor phrases like stop animal testing, torture, and hurt. This is brazen discrimination against criticism of the agency's own role funding animal testing, and it distorts public debate about the NIH's priorities and its practices. The
We
district,
no longer ban stop animal test or hashtag stop animal testing, correct?
that's right, Your Honor. After this case was filed, the NIH removed a few words from its list of blocked keywords, including stop animal testing and PETA, which it had also previously censored. But that
So are
decision,
we supposed to, this is just for injunctive relief, this case. So we're just supposed to look at the policy in its current form?
no, Your Honor, I think you also need to look at the policy as it was implemented when the case was filed. That's because although those keywords were removed, it hasn't been accompanied by any statement from the NIH that it will not block those terms in the future. And there is nothing in the district court's opinion that would prevent it from blocking those terms again tomorrow. So I think they're still relevant to showing why the NIH's conduct here was viewpoint discriminatory in and of themselves. They're also relevant because I think they color the rest of the list of the blocked keywords that's at issue in this case. Words that are still unblocked like torture, torment, hurt, stop, kill. These words are all indicative of criticism of animal testing rather than animal testing as a subject matter. And I think that's made even clearer when you take a step back and look at the NIH's overall course of conduct. Now, it's the government's burden to prove that its
But
conduct.
this is something that I find difficult. All these points you're making would be relevant if you thought intent is what mattered for viewpoint discrimination, but it's quite emphatically not your position that intent matters. Is that right? So I think we have to do some form of looking at these keywords objectively to decide whether they are on their face viewpoint discriminatory. Is that right as a methodological matter?
I think that is right, Your Honor. And I think when you look at the list of keywords themselves, looking just on their face, you can see that the keywords themselves are evocative of a particular viewpoint, right? Cruel, revolting, stop testing.
So can you, this is sort of related to Judge Millett's question, but how are we supposed to do this? Is it word by word? Do we just look at them as a whole and say this policy as a whole on its face discriminates? Because this could get tricky given, for example, that they've removed some of the terms. And can you lay out how you would tell us to write that in an opinion?
Yes, Your Honor. I think you should look at the list of blocked keywords as a whole, and that's the list that we've highlighted at JA 76, which is the joint stipulation. The reason for that is the government has always defended this list as a whole. It hasn't highlighted any of these keywords as not being targeted towards the criticism at issue in this case. And I think the fact that the NIH is targeting criticism as a kind of objective indicia of its intent here, intent as in a desire to block off a certain viewpoint and treat it disfavorably, not intent as in benign motive here, is made even clearer by the overall record, right? The NIH has argued in this case that it's enforcing an off-topic policy. Now, it's the NIH's burden to prove that that's true, that its conduct is not, in fact, viewpoint discriminatory. And the overall course of conduct here, I think, just undercuts that argument entirely because it is so over-inclusive and under-inclusive when compared to the NIH's goal. It's over-inclusive because this undoubtedly suppresses speech that is on topic, even under the NIH's narrow view of topicality. And, I think the NIH will tell you that this is a small amount of speech on its social media pages, but it's not. There are 37 different Facebook and Instagram posts in the record. Over a third of those posts directly reference animal testing in the text of the post itself. Promote us.
It feels to me like there's a bit of talking past each other in this case, because their argument is we're not blocking these things because of the particular viewpoint. We're blocking them because they are inundating. These are the words that are inundating our comment threads so that other comments get lost, so that people get deterred from coming to our pages and commenting themselves, that these comments are suffocating our Facebook and Instagram comment threads. And so that's why we have picked those words. One, is it accurate? Is that flooding accurate? So whether or not the subject post is about or implicates animals or animal testing, these comments are flooding their comment threads, or were before the keyword stops, flooding it and just sort of hijacking the comment threads.
No, Your Honor, I don't think that is accurate. The government points to a handful of exhibits, and it's certainly true that in those exhibits there is a high volume of speech criticizing animal testing. But there are many other exhibits in the record that don't feature any criticism of animal
I'm
testing.
not clear to me whether those ones were post-keyword blocking or not, but it seems to me like, I know you all did a stipulated record, but if their theory is this inundation or hijacking of our comment threads, and yours is viewpoint discrimination, there's a critical facts that need to be resolved here about this volume. If take it away from your client, but if there were some entity, the Flat Earth Society, and every time anything was posted on NIH or the US Geological Service or NASA, they would blast it and drown it with flat Earth advocacy. In that situation, if an agency were to block flat Earth as a keyword and not block round Earth comments, would that be viewpoint discrimination in that scenario? I know factually you don't say that's where we are, but we just don't have a fact finding one way or the other. But if we had such a fact finding, agencies have no capacity on their Facebook pages, on their Instagram pages, to control in any way the subject matter of comment threads.
They do. They absolutely have that authority, Your Honor. And the NIH could have taken a number of different courses here, right? It could have used manual moderation to ensure that it was actually—
Let's just assume for government agencies or for others that have hundreds and hundreds of thousands of people following their websites, government doesn't have the resources. They would rather, during a pandemic, spend their resources on dealing with public health issues than manually moderating comment threads. I think that is an unrealistic way of assuming the government is supposed to function, is manually reviewing that. And by the way, if they were doing that, y'all would be bringing challenges about the lack of guidance and the uncontrolled discretion of the manual monitors. So I'm not sure that's an answer. When you have the situation where certain speakers with a common thread, at this point, maybe they've even got bots doing it for them, are suffocating a government web page's comment threads. That's not an objective, non-viewpoint based. We're picking the words based on the volume of appearance, extraordinary volume of appearance, and the consequences of that, not their meaning.
Well, Your Honor, I want to make 3 points in response to that. The first is, as you say, I do think there are factual questions if what you're focused on
is summary judgment on this record too. You both did. That's what's difficult about this.
That's right, Your Honor. And I think there are factual questions if you think the government's subjective intent matters, if you think that it is allowed to discriminate on the basis of viewpoint, if it has a viewpoint neutral rationale for doing so. We don't think that's true, but I do think that more fact finding would be required.
You just said even if they don't care about viewpoint, they are only targeting volume words and volumes at extraordinary level. It sort of hijacks their page.
That's right.
That's still viewpoint discrimination.
That's right,
your
because
motive.
it's not about the
What's your best
motive.
case for, not motive, I'm talking about objectively, they can demonstrate in the record the volume, the consequences, and that the only words they've picked are the ones that are throttling their social media communications.
But I think the
What's your
problem
best
here,
case that that's still viewpoint discrimination? We're assuming now there's no subjective intent and the objective explanation is related to something unconnected with viewpoint.
I think you need to look at cases like Lamb's Chapel, right, where the court said, even if you have a justifiable reason for wanting to keep religion out of school facilities, when you target religion, even if you target all religions and you prevent religious speech on otherwise
Was
includable.
deliberate conscious intent to keep a particular viewpoint out on subjects that were already being discussed because of the viewpoint. It was not a case where, it's hard to imagine how this would happen in a physical facility, but if they opened the doors, there were going to 8 million people trying to squeeze into the high school gymnasium. And so we said, it turns out every time it's a religious group that wants to speak here, they bring 8 million people and we have fire hazards and we get the whole place shut down. And they said, so we just can't let these groups that have 8 million people, and the list of those groups happens to all be religious groups. That would
Well-
still be viewpoint discrimination at Lamb's Chapel? When they have an objective reason for doing that's
I
not
think-
related to content.
I think that would be a different case, Your Honor, because,
What I'm hypothesizing.
well, I think in that case, it would depend on the government's justification. If it could build out a record, then that might be a sort of content neutral reason
So if
for
you could
limiting.
build out a record, I don't know if they could or not, we don't have these facts. But if government could in some case, my flat earth hypothetical, build out a record that says the amount of flat earth commentary, no matter what we say, what we do, what we post, is suffocating, drowning our comment threads. And it's just volume. We're just banning the volume words. If it was round earth, we would ban that too. That would be okay. I get that you don't think that's the record in this case, but
I don't think that would be okay, Your Honor, using keyword blocking. And I think there's a difference here between whether or not the government has a legitimate motive, has a legitimate reason to moderate or regulate that speech in some way versus the tool that it's used in this case, right? Because in this case, the government itself references animal testing, and it does so with regularity, but it prohibits commenters from raising concerns and criticism of animal testing, even on those very posts, right? It's not a question of a post-by-post analysis of what might be on topic or off topic. The NIH has
my
treated.
hypothetical about the gymnasium, there's going to be people there. I mean, amongst those, and maybe all 8 million people are going to be very interested in talking about the same topics that other groups are talking about. Those other groups simply are not causing the system to break down in the way that the 8 million member group would.
That's right. And I think that analogy
So if they were to had a record that showed that these keywords reflect sort of the internet equivalent of the 8 million member group, so that everything just stops working in the comment thread, then it would be okay. But that's simply a record that hasn't been developed yet.
Well, I think it's both the fact that there isn't evidence of that in the record and the fact that this is so different from the kind of physical analogy that you've raised, Your Honor. That's because, in the physical world, I think the analogy would have to be that you have an event in which a lot of people are bringing up concerns, right, about flat Earth. And in a physical world, you might kick those people out, prevent them from speaking further. What's happening here looks very different. What's happening here would be equivalent to, I think, NASA saying at this event, these flat earthers are raising comments that we think are irrelevant and we think they're preventing other people from speaking. So we're going to go and purge every mention of flat earth from every public event we've ever had. And in the future, when we talk about the flat earth controversy ourselves, we will prohibit people from bringing up those concerns. That's the effect that keyword blocking has here. And that dramatic over-inclusion demonstrates that there is such a poor fit between what the government says it's doing, which is invoking an off-topic rule, and what it's actually doing, which is blocking this criticism, regardless of whether it is on or off topic, that an inference of viewpoint
sorry, I just want to make sure I understand your position. So with the gymnasium hypothetical, I thought your position would be that if the policy came out, no more religious groups, that's because it's facially viewpoint based, that is unconstitutional, right? And instead, what the school would have to do is come up with a facially neutral policy that said something like groups that bring 8 million people are not allowed. And then you'd have an inquiry about intent, correct?
Well, I think then you'd have an inquiry about the justification for that rule, no groups of X many members allowed. And you want to make sure.
But the threshold issue is the policy facially neutral, right?
Yes,
And-
because
and in flat Earth, if the big problem is everyone saying the Earth is flat over and over and over again, is it your position that if the agency wants to do something about that, what they need to do is ban discussion of the subject of, I guess, the shape of the Earth, but what they cannot do is say, we're going to ban this one viewpoint on that otherwise includable subject?
Yes, I think it's very clear that the agency cannot ban one viewpoint on an otherwise includable subject.
So
That-
what if they're, just to follow up on that, if you'll permit, if they have a list of 10 groups that always come up with 8 million people. They've done it many times. They happen to all be religion groups in your Lamb's Chapel world. Are they allowed to ban those 10 groups?
I think it would be very difficult to constitutionally ban those groups forevermore. And that's the way keyword blocking functions in this case. I think the case really could.
Can I just to return to the,
Yes, Your Honor.
because I want to know if I understand what the
Yes.
point is correctly. If that policy said, we are banning going forward any group that has been here 5 or more times and caused XYZ problems, that would then be a facially viewpoint neutral policy, right?
Yes, exactly, Your Honor. And so I think here, this court's consideration could start and stop with the fact that the words blocked themselves evince a viewpoint. But digging in even further, I think the record makes clear that there is discrimination because of the way that it functions to prohibit perspectives on otherwise includable subjects, things like the development of the COVID-19 vaccine, things like the studies relying on animal testing that the agency itself brings up.
Seems like just basically the use of keyword filters, if your view of the law is right, is extremely difficult. Because it sounds like to have a facially neutral keyword policy, they just have to come up with some pro-animal testing commonly used words and block those as well, so that they could claim what we're actually doing is blocking off the whole subject matter. And that, I think they would get up and say, that's just impossible because we don't have the record of what, words are associated with those types of views. And so we can't, use keywords that are balanced on this issue. What's your response to that?
Well, I think the problem with keyword blocking as a means of enforcing an off-topic rule is that it's totally untethered to that goal. Keyword blocking may be a useful moderation tool as a means of enforcing other type of speech limitations where context isn't required to determine whether speech is in or it's out. But because it can't do that function right now, as it's currently instantiated, keyword blocking applies to the whole page. It can't go post by post. And so there's no ability to use nuance in determining which subjects and which comments are includable and which are not. So it is a very poor fit. I think it would be difficult to justify the use of keyword blocking as the sole means of enforcing an off-topic rule. And that's exactly what we have here, because there is no evidence in the record that even before the NIH felt that it had especially limited constraints due to the COVID-19 pandemic, there's no evidence that it ever used manual moderation against any other type of off-topic speech. And we've pointed to several examples of other types of off-topic speech. Off-topic speech about COVID-19, for example, appears on 12 of the exhibits in this case, even where that is not raised at all in the post.
Just to understand your answer, Judge Garcia, can they use keywords to try to filter out solicitations?
I think that might be a circumstance in which keyword blocking could be used in a way that is more tailored to the goal at hand, right? Something like a profanity filter where the discussion doesn't really turn much on the actual context of the comment, but the inclusion of those particular words. What makes it such a poor fit here?
Well, it includes some of their comment guidelines include personal attacks of any kind. So if they filter out, if there's 5 people who are the objects of the worst vitriol in comment threads, sort of across time and across the page,
Well-
can they ban comments about those 5 people?
They might be able to do so. That is not what the government is arguing. It's doing.
I'm asking your position. So, because you've mentioned a couple of researchers and they've banned those names. I fear that those two, there's 2, sorry, I forget the names of them.
Harlow and Suomi, Your Honor.
Harlow and Suomi, yes. So that's okay. If that, again, there's a lot of factual development here that's missing. If they did that under, not under off topic, but under personal attacks of any kind, they can use keywords for that.
Well, Your Honor,
It'd be overkill, but
I think keyword blocking would be more tailored to the government's goal. I'm not sure whether it would be constitutional though, because it would.
I mean, that's what I'm asking you is whether, is the implication of your argument that keyword blocking just can't be done unless it's for, was it George Carlin's 10 dirty words or something like that?
Yes, I think keyword blocking by itself, as the tool is currently available to users, can only be used in very limited ways. It might be with enough of a record that banning certain people who are exclusively the targets of abusive language, that might be constitutional. I think that would really matter with the factual development.
Are you, again, you also sought summary judgment on this record, so I'm not sure it's.
That's right, Your Honor. And
we
there's,
need more records. So do you challenge or not the use of inclusion of Suomi and Harlow, at least on the Facebook?
yes,
keywords?
we do, Your Honor, because there is no evidence that the NIH blocked those terms because there were comments that violated its prohibition on personal attacks, and there's no evidence that would
If they were to
support.
say that, though, then it would be, they just didn't say the right thing, is your view? If they said that, it would be fine, or do you still think it wouldn't be fine?
No, they would need to say it and they would need to prove it, Your Honor. And there's no evidence that there have been personal attacks against these researchers that would allow the NIH to enact a prior restraint on anyone mentioning those names. But again, I think
I know prior restraint language, that's great. You love that language when you're on the side of the First Amendment case, but this is a limited public forum here. We're talking about what the rules of dialogue are that they can set, and every rule of dialogue, I mean, everything in the NIH comment guidelines is a prior restraint.
Your Honor, I want to make
Everything is, right? Obscene language is a prior, banning obscene language or vulgar language. That's a prior restraint, right?
well, Your Honor, I want to make 2 points here. And the first,
Banning speech that has racist connotations is a prior restraint. I'm right?
well, Your Honor, I think the
Competitive
question,
posts is a prior restraint.
I think the question is how those rules are enforced.
Okay, but it's not that they're prior restraints when we're dealing with a limited public forum like this.
Well, again, Your Honor, I do want to make 2 points. The first is that we've argued that this is an open public forum, and that's because the agency has not sufficiently limited the forum to on-topic speech. All it does is ban these keywords that relate to criticism of animal testing. It doesn't enforce that guideline or really any of its other guidelines against any other type of off-topic
Are
speech.
images or videos showing up
Yes, Your Honor.
here?
If you look at Exhibit 1 in the record, you will see many images. You will also see external links.
And one thing I was a little confused, maybe you can clarify me on the appendix. Is all of the appendix before keywords were being used or since they've been being used?
No, Your Honor, these exhibits, most of them come from before, most of them involve the NIH blocking, the NIH page as it currently exists, so with keyword blocking in place.
Okay.
But I do want to get to, I think, the heart of your concern about the difference between all of the rules that the NIH has and the keyword blocking at issue in this case. So we're not objecting to the NIH's comment guidelines, but it's important to note that they don't enforce those guidelines against speech generally. All they do is have keyword blocking. And what makes keyword blocking different from a rule that says no vulgar speech is that typically in the normal course, you might have a comment that includes some vulgarity and someone might see it and take it down and possibly write you a note. The speech is out there. What makes keyword blocking so different is that it's automatically hidden. It's hidden with no notice to the commenter, and there's no notice to the people going to the comment thread, right? They believe this is an open thread for discussion on all topics. If you look at things like Exhibit 1, Exhibit 10, Exhibit 38, you'll see a kind of freewheeling discussion on lots of different topics. They don't.
is this notice to the speaker something they choose, or is that just default how keywords work on Facebook and Instagram? Keyword blocks work.
Well, that's the default, but the NIH could choose to notify the public and notify the speakers
Sorry,
of.
would they, so this is my technology limitations. Is there some they can toggle off when they use keywords, or are you saying that they would have to manually notify everybody? Someone would have to monitor every keyword catch and then manually notify somebody.
Well, that is one option, but I think the
Is there
bigger,
a technological, if one thinks this isn't feasible,
I
because
don't
of
think,
resource limitations.
I don't think there's any technological fix at
So
this
that's
moment.
really a Facebook, Instagram issue that people don't get notice of this.
I don't think so, Your Honor, because the NIH doesn't even inform people going to its comment threads that it's using keyword blocking at all. And that would be a essentially cost-free way of providing notice to people of how the speech environment has changed. It would inform them of what is going on. But right now, we have what looks to be an open forum with the government in the background, kind of plucking out disfavored
The comment
speech.
guidelines are now linked to the Facebook and Instagram pages.
The-
So people have noticed that if that's what they do, it may get blocked.
But the comment guidelines don't say that the NIH is using keyword blocking against this type of speech. And that's the sort of distortion that I think is so problematic here, that people are going to these threads without understanding that criticism of animal testing is being pulled out of discussion, even when animal testing is raised by the NIH itself. I mean, I think that's just a core flaw of the NIH's keyword blocking scheme that really can't be overcome, even if it points to additional examples where there is a high volume of speech about animal testing.
Just one last question. In their brief, the government relied heavily on cases like Madsen. And I guess the simplified version of why is that they say the effect of that restriction was just to limit the speech of anti-abortion protesters. And so too here, it's okay to limit just this side of the debate because that's where the problem's been demonstrated. Could you just give us your hopefully brief distinction of that case?
Yes, and I know my time has expired, so I will try to keep this with 3 just brief points. The first is that Madsen arose from an injunction that was targeted against a particular group of protesters who had already interfered with access to the clinic. It did not apply to all people who, believed abortion was wrong. The second is the way in which the state in that case, the court in that case actually effectuated the goal of prohibiting the speech, right? It did so through content neutral means. It mostly relied on the volume and the location of the speakers. It did not ban words like pro-life. It did not ban words like unborn. So it did not target in a viewpoint discriminatory way. And the third reason is that even with that content neutral injunction, the Supreme Court narrowed it further to ensure that as much speech as possible could occur as long as it wasn't overriding the state's interest in allowing patients to receive medical treatments without undue anxiety and negative health effects. That sort of tailoring is totally absent in this case, where the NIH freely admits that it blocks on-topic speech it has absolutely no justification for suppressing.
Okay, thank you.
Thank you, Your Honors.
Good morning, Your Honor. Jennifer Utrecht on behalf of NIH. At issue in this case is NIH's efforts to address a seemingly coordinated campaign to flood its social media pages with off-topic commentary related to animal testing. The plaintiffs object here that those efforts have successfully stymied their attempts to, for example, make off-topic comments on posts about Public Service
So-
Recognition Week.
Can you define or tell me where the record defines off-topic?
So off-topic is a term that I think is commonly understood. It's used in
It's not
policies.
commonly understood by me in this context at all. Does it mean off-topic for the NIH page as a whole or for each particular post?
So I believe the stipulation refers to the policy being, has to be on topic to the posts. And the posts.
That's in your lawyer stipulation, but I haven't seen any evidence of any actual NIH definition or guidelines or anything that define
There's nothing in the
what off-topic means.
There's nothing in the comment guidelines that define what off-topic means, but as the district court here found, off-topic is a term that although people might disagree on the margins about what is or is not on topic, there is a pretty general understanding, at least for the majority of things, of what is or is not
Well,
off
Is
topic.
the topic sort of limited to the narrow subject matter of the posting, or is it that this is the government posting? Government produced this information a certain way. Is that part of?
I think
the
that should
topic?
be, the topic should be understood, of course, in light of the purpose of the forum. And, the NIH's social media pages are used to disseminate information about public health resources for people to address public health concerns and to talk about.
They're the government. If someone's criticizing how they came to have that information, isn't that a legitimate topic in our country?
It's not that it's not a legitimate topic, Your Honor. It's that what's happening here is that the vast majority, the overwhelming majority of comments about animal testing are not on posts discussing, tests or research about animal testing. They're on posts about Public Service Week, posts about caregiving resources for individuals with Alzheimer's. I mean, there's really no dispute. And
Like there's been no, similar to in the brief, there's no consideration of what NIH's posts are actually about in the stipulated record. So just one example, this is JA 203. This is the zebrafish eye picture. It's, I suppose, quite literally a post about animal testing. And is it your position that it's common sense that criticism of animal testing is off topic?
no, Your Honor. So I think
That's the effect. of the policy.
I think we agree and that keyword filters are an imperfect tool, and that if you are using them to screen for off-topic commentary in a situation like this where there is a huge swath of comments that are off topic, it's going to occasionally capture comments that are on topic. We're not disputing that. That is an inevitable result of the use of keyword filters. But unless this court is going to say that keyword filters are per se unreasonable because they have to be tailored and never capture on-topic comments, then the record here does show that these keyword filters were chosen to address a significant problem, which was this coordinated effort to flood NIH's pages. And
It's more of a framing point to back up. Do you agree that if these keywords, we think they're facially viewpoint based, then the government's intent and justification doesn't matter?
So they're not, I would
Because
dispute
facially viewpoint policies are.
I would dispute the first premise that they're not viewpoint based. And I think that's always what.
Absolutely understand that. But if assume they are, we think on their face, they are viewpoint based, then you agree, right? That the intent, the justification, everything else is irrelevant.
If the terms are on their face viewpoint based and were not added for the purpose of viewpoint, I mean, I think that does matter, Your
That's
Honor,
the intent
because
question.
of course, if what is happening is there's an empirical flood of, for example, one word posts that say stop animal testing. And that comment or that term is filtered because hashtag stop animal testing is posted hundreds of times on posts that are not about animal testing at all. Then what's being done there is we are filtering for off-topic commentary, not for that particular term, not for the, what that term reflects. And we're not, and the fact that it might have an effect on a particular type of speech because the people who are repeatedly violating the off-topic policy all have a particular viewpoint, that in and of itself isn't viewpoint discrimination if there is a viewpoint neutral reason for what the government has done. The plaintiffs have cited other cases.
The issue, the difficulty, I think, is that what the cases say is if you have an otherwise includable subject matter, which here I think would be the subject matter of animal testing, in the same way in Lamb's Chapel, the subject matter was views on child rearing. You cannot have a policy that bans one view on the otherwise includable subject. And it is hard to look at these terms and not conclude that there is a broad-based effort, or effort's the wrong word. The effect is to screen out anti-animal testing views.
So, Your Honor, I 2 points as to that. The first is, so for using the term hashtag stop animal testing, for example, I'm not sure what the equivalent is on the opposite side to filter for. To my knowledge, there isn't a hashtag that's used for the opposite side of the debate. And and a second point is if there was a hashtag that was used frequently by people who supported animal testing, and that was flooding the comment section, NIH would also filter for that. And there's the record here doesn't, because of that, the record here doesn't support the inference that plaintiffs have asked this court to draw, which is that because we have picked the terms we have, that in and of itself reflects viewpoint discrimination.
I think what they're asking us to conclude is that the natural effect of these keyword filters is to filter out one viewpoint on this allowable subject matter and not the other. And I am very sympathetic to the administrative convenience points, but I cannot find a case that says viewpoint discrimination is justified when the administrative burdens of, blocking both viewpoints are too high.
So I think then it would be helpful to say, the way that viewpoint discrimination is typically analyzed is we look to whether the government has asserted a viewpoint neutral reason for what it has done. We have. And then, plaintiffs have asked, despite that viewpoint neutral reason, for this court to nevertheless, to infer viewpoint discrimination because of the surrounding circumstances, because the terms that we have picked, despite being picked because they were a lion's share of the off-topic commentary, were picked to suppress their viewpoint. And the evidence, the totality of the evidence here, as the district court found, doesn't support that inference, in particular because plaintiffs haven't identified any type of comment that is similarly situated. I know there's been extended discussion here in this courtroom about what the record does and doesn't support in terms of how common off-topic commentary regarding animal testing was. But I would point this, Your Honors, to the district court's opinion on page 26, where it notes that the plaintiffs didn't meaningfully dispute the factual premise of our argument, which is that off-topic comments regarding animal testing were a huge majority, the lion's share of off-topic comments on NIH's pages. If that had been something that was disputed.
Did you meaningfully document this flooding problem?
So there are a number of illustrative examples that are highlighted both in our brief and the district court's opinion. So exhibits 14, 16, 17, 18, they all illustrate dozens and dozens of, sometimes one word, sometimes two words comments saying puppy killers or hashtag something.
So dozens and so 24, 36 posts on a comment thread is.
Well, so for example, on the Alzheimer's post on exhibit 17, I believe there were 500 and something total comments, and more than 100 were related to.
A fifth. That is the government's definition of sort of hijacking the comment thread.
And so, again, Your Honor,
Is that
that is an illustrative example of what NIH perceived.
Your actual test, and your test is that dozens or a fifth are sufficient to overwhelm a comment thread. That's the test. That's the line the government's adopting.
It's not
Otherwise,
one
it's
post,
not
but it's not
illustrated.
one post, Your Honor. It's numerous posts. There are several examples in the record, and if plaintiffs had meaningfully
Well,
disputed.
they show up on a lot of posts, but if they aren't sort of suffocating those posts, which I would have thought would be a 80 to 90% domination,
So
then maybe there's just a lot of people who care about this.
there are other examples, Your Honor. For example,
What's the
one
worst-
individual.
best flooding example you have?
I would direct Your Honor to the Alzheimer's post where there are, I don't know the exact number of puppy killer comments that are on that, but it is a post about providing resources to individuals who are caring for family members and loved ones with Alzheimer's, which has nothing to do with animal testing at all. And those resources that NIH is sharing and providing a space for people to talk about those resources and their own experience are being drowned out by a substantial portion of comments that aren't about the post at all.
No, please.
I'm just not sure what drowned out means in comment threads on the internet.
So
Everyone else can still comment. They can skip past things and scroll quickly. It doesn't stop anybody else from commenting. So what is this?
Well, so
test?
there are other examples, Your Honor. In the stipulation, it notes that individuals have complained because they've missed NIH. They have missed attempts, tweets from NIH about resources because there were.
Twitter here, and the comment threads do not obscure or affect in any way access to the NIH posts, the substantive posts themselves. The comments, I don't know if NIH joins in the comment threads. I may have seen one where maybe somebody, it looks like somebody did, but generally the comment threads are just people talking to other people. So I'm not quite sure how the comment threads are going to interfere with access to NIH's speech and information.
It is interfering with the ability of commenters to discuss the topic of the post with each other, to ask NIH questions about the post. I mean, if
Do you think these threads are somehow different than threads elsewhere on the internet that really almost any subject matter anywhere, there's going to be people there spewing in garbage?
so, I think it might be
People
helpful,
showing
Your Honor,
relevancies?
accepting the premise that this is a limited forum. I think it might be helpful to take us out of the internet world where moderation is understandably difficult. If, for example, someone were hosting a town hall.
No, I don't think it's helpful to go there. I mean, I know you want to, but this is, if you want to say town hall, it's like the government gets there, makes its presentation, and then says, okay, we'll be over here if you have questions, but otherwise the rest of you all talk. That's what the comment thread is. The rest of you all talk. We'll be over here if you have questions, but the rest of you can talk about whatever you want.
Well, the rest of you all talk within the confines of our comment guidelines, which specifically say that comments have to be on topic,
But
among other
you keep talking
restrictions.
about, you talk about this as a volume problem, which is not the same thing as a topic problem. Volume and topic are very different. And that's what I keep hearing is they're flooding it so people can't get other information. But
So maybe,
you think it's not relevant to Alzheimer's, but if they see Alzheimer's and they go, I know how the NIH does Alzheimer's research. And so I want to let people know, don't be thinking the government's nicey-nicey here when it says, here's some advice to you as you deal with Alzheimer's for someone in your family. We want you to know what this government is doing when it's dealing with Alzheimer's. Now, people have different views on that.
so,
It's a terrible.
Your Honor,
disease.
I think it should be unobjectionable that if NIH were to say, we want to provide a space for individuals to talk about our public health research. We do not want this space to devolve into a discussion of the ethics of animal testing. And so that topic is off limits. That would be appropriate.
All right, you think they can categorically make animal testing banned anywhere on the NIH website?
In a limited public forum,
Even when it's on topic, if you post about animal testing?
that would be a content-based restriction. And I think there's
No, this is the exact same website. And let's say once every 6 months, there's a post on there that talks about experiments that were done on animals or new rules about improving conditions for animals in NIH testing facilities. But you've got this keyword
and I think it would.
in here.
So if there were a policy that that clearly prohibited discussion of the ethics of animal testing, if NIH were to say, for example, there has been a documented problem of all of our attempts to discuss public health and efforts to address human health, that devolving into discussion about animal testing, and that's not what we're hosting this page for. There are other places for people to talk to NIH and others about the ethics of animal testing, and that is not what this page is for. That would be a content-based restriction, and this court would address whether that was reasonable or not. What's happened here is not that different. We have the vast majority of NIH posts do not discuss animal testing in any way. There might be a few examples the plaintiff have pointed to that reference animal testing, but overall they are posts about human health.
There's a fact finding that the vast majority of your posts do not implicate animal testing.
So the relevant fact finding here is that the district court found that no one disputed that the overwhelming lion's majority share of off-topic comments on NIH's page are off-topic comments about animal
That is just
testing.
begging the very question that I just asked about whether animal testing is off topic. Because it's one thing to say they're only on topic if the topic, if what the NIH post itself is animal testing. But if in fact it is, newly discovered treatment for X, and background information lets people to know that the way that was discovered was through animal testing, and someone wants people to know, don't get excited about this, understand the price that was paid for this development, if that was the speech they wanted to do, that doesn't feel off topic to me, but it sounds like you're putting that in the off topic category.
Your Honor, looking at the exhibits that we have before us, which were those exhibits aren't reflective of that sort of commentary. The majority of these exhibits make no attempt to be on topic. They're one word, sometimes 2-word posts on things that are, like, for example, caregiving resources for people with Alzheimer's.
Counsel, I don't think the question is about the comments. It's about NIH's posts. And what PETA says is that over a third of the exhibits on their face seem to be, at least arguably, the kind of posts where a comment about animal testing would be on topic.
So I see 4, possibly 5 examples the plaintiff have cited in the exhibits. Notably, I think there is only 1, maybe 2 comments that they've actually identified that were on any of those posts. Oh, their complaint says that they were frustrated by their ability to post on Public Service Recognition Week and Diversity in Science. I mean, they've admitted that they want to use posts that no one has argued have anything to do with animal testing as a place for them to advocate for animal testing. And
Where have you shown the flooding? I'm still trying to understand that. It's to say what they haven't shown. But you have a list of words here that's at least eyebrow raising, and I haven't, and your argument is you're equating flooding the comments with being off topic without any factual evidence of flooding. Or at least what you've given me, I would maybe, I'm just wrong. I would not consider dozens on internet comment threads, which can go on forever, to be flooding. I wouldn't consider 1 out of 5 flooding, given that people have abilities to search through these things.
So, Your Honor, to be clear, the other off-topic posts that don't have to do with animal testing also violate the guidelines. The problem is that there is nothing else that exists in this universe that repeats the same sorts of words that would make them suitable for filtering. And that's why, I mean, so flooding has to be understood in that sense. The reason why NIH has picked the words it has is because these comments share a common theme. They share the common words. And when I say flooding, I mean, it's a group of comments. It's a concerted effort that we can target through filtering. Whereas
test, the word test, categorically off topic for NIH.
I don't think
That's on a keyword.
it has never been our position that the word test is categorically off topic.
But you're blocking any post that has that word.
It has been our position that the word test was recurrently used in comments that were off topic.
More
And that
frequently
is,
than say COVID test.
in fact, that would probably be limited. I'm sorry, a comment that said COVID test would also be filtered. Yes,
No,
Your
no, but I'm
Honor.
asking you, but you're doing the inundation argument here as a record evidence that test is used so overwhelmingly more by those who support or those who oppose animal testing than those who in 2020, 2021 wanted to ask about COVID tests.
So
evidence
the
of
stipulation
that?
doesn't say when the filters were first adopted. It does say.
And it's showing really that test, what is the evidence that test is overwhelmingly used in an off-topic rather than on-topic postings for NIH?
So the exhibits are what the exhibits are. And I recognize that I
I
keep.
get the exhibits are what they are. I'm going through your keyword list here.
Right.
And I'm asking, is there any what is the factual basis for a facility like NIH to say we can't let anybody post a comment that has the word test in it?
The rationale is the same as it is for all of the other filters, that in NIH's experience, all of the terms in the filtered lists, including the ones that plaintiff does not challenge, were terms that were recurrently used in off-topic commentary. And when we're talking about a limited public forum,
What recurrent meant? Is there any concrete?
we don't have, numbers. No, it's not in the stipulation. There was not discovery in this
I
case.
mean, if the government's theory here is not really off topic, but sort of suffocating volume, isn't that a fact question that just has to be established?
So again,
Or do you think we should decide it without having that information?
what I find the question of what the facts are to be a bit frustrating because of the way plaintiffs have chosen to litigate this case.
The government as well on it's a joint stipulated record.
So
you
if
both
I
decided to litigate it.
If I may, Your Honor, the joint stipulation says on paragraph 46 that the parties will not unreasonably object if the government or the plaintiffs want to add additional exhibits in summary judgment based on what's on NIH's pages. Our summary judgment briefing said that the reason we picked them is because animal testing comments constituted a lion's share of the off-topic commentary, that they were uniquely suited for filtering because they shared these common terms in NIH's experience. And that was not a point, that factual premise was not something plaintiffs meaningfully disputed, so we didn't enter additional exhibits for that point. The way plaintiffs have instead chosen to litigate this is assume that factual premise, assume that they're the lion's share, and nevertheless, you should infer viewpoint discrimination based on the specific terms or
Is 1/5 the lion's share?
of a single category of off-topic comments. I mean, it's for 25%.
What do you mean by a single category of off-topic comments? You said there was a thread in which about 1/5 of them, read, was it I think it was the Alzheimer's one you referenced.
There is not another category of off-topic commentary that comes anywhere close to that. There's not anything where there's common terms used discussing a different topic. There just isn't, because there isn't a concerted effort to flood the pages with these kinds of commentary.
I'm kind of surprised, honestly, maybe I just shouldn't speculate like this, that certainly through the COVID era that anti-vaccine posts were not pervasive.
So there are certainly exhibits in the joint stipulation where there are commenters who say things that are that reflect a certain viewpoint on vaccinations. They're usually on posts about vaccinations or about antiviral treatment for COVID-19. And they're not single word comments that are multiple people are posting the same thing.
Dr. Fauci gives speech at X place. And the speech, it's a commencement speech encouraging people to go into public health. During the pandemic, people wouldn't have covered that with a lot of anti-Fauci, anti-vaccine comments.
I'm not going to take an empirical position on that one way or the other, Your Honor. I think what we have here is...
Well, at some level, NIH's position here is, this is a unique problem for NIH. Because if in fact you had problems with anti-vaccine stuff showing up anytime Dr. Fauci was mentioned, COVID was mentioned, even if not talking about vaccines, and yet nothing was done, that would be a problem as well. And I understand sort of the stipulated record here, but I don't think it's enough at summary judgment for a summary judgment brief by lawyers to say there's a lion's share here that is overwhelming the comment thread, which are simply characterizations without any factual documentation.
So 2 points, Your Honor. The first is our policy against off-topic commentary is not a policy that off-topic commentary is permissible unless it overwhelms. It is a policy that we don't want off-topic commentary because of the threat of overwhelming. The reason that we have addressed these comments is because there are multiple users posting substantially the same thing, sharing the same words on and those words are the ones that we're filtering for. And there's no evidence that that was true with respect to anything else. Even the exhibits that are critical of vaccinations, they don't have that same, here are multiple people posting substantially the same comment over and over and over again on a particular thread. And without that, there isn't a great basis for us to pick a filter to address that kind of off-topic commentary. But with respect to the comments that led to the filters that were chosen, there is this commonality between multiple users posting substantially the same thing over and over and over again, which makes it uniquely suited to keyword filtering.
Counsel, can I ask you a question? It seems like if we agree with you on a lot of the issues in this case, so it's not viewpoint discrimination, we agree with you on forum. The last question becomes, is this policy reasonable? And the policy being, we're going to ban off-topic posts. And one of the requirements for that is just that it be workable, subject to, consistent application, which I think in a practical way just means where most people understand what it means.
Right.
And so I just want to understand, obviously there are you say few posts that are directly about animal testing. There's also a bucket of posts which are about the research of scientists who are known to conduct a lot of animal testing. And I guess I'd like to understand, would a comment, and there are several examples of this, saying, stop animal testing. This guy does a lot of animal testing. Is that off topic?
So I understand that plaintiffs disagree with us that about what the topic of NIH's posts are. I think it's reasonable to assume that an agency that posts about public health, whose purpose is public health and sharing information about public health, is hosting the forum for the topic of the discussion of public health. And
so I think that's a completely reasonable position, but sort of as you said, the other side is reasonable too. And it seems to me the problem in terms of the case law is that your guidelines don't explain. If your guidelines explain what you think off topic means, that might do something to remedy this problem. But right now it just says the word off topic. It's very difficult to know whether on this kind of post or a whole host of others, whether something is actually off topic if I'm someone who wants to post.
well, Your Honor, I would note that the term off topic is pretty regularly used in social media policies. It would be extraordinary to suggest that that's not a sort of thing that's capable of reasoned application. I know that I appreciate the point that on the margins, there can be some debate about whether something is on topic or not. But at bottom, I think as long as NIH is not acting arbitrarily and deciding that its posts are about public health, and that's the sort of thing that would withstand First Amendment scrutiny under the limited public forum test.
So I'm trying to also understand technology, how this works. So you say we're looking at comment threads post by post. When NIH posts, I guess their tech person posts an article, is any judgment made at that time to turn on or off different keywords? Or is this list that we have in the record, J76, a static list?
I
Put aside the changes that were made post litigation.
I am not sure what is technologically possible. I have theories, but they're not in the stipulation, so I'm afraid of speculating.
No, I'm just looking
based
what
on-
NIH does. I mean, do they make any effort to check and see, are there other words that get added for certain posts
Oh, I see.
or some turned off?
So the filters
For
apply.
example, if we're talking about COVID tests, do we turn off blocking the word test in comments?
The filters apply across all posts. I don't believe there's a technologically possible way to turn them off for just one post. And I would emphasize, Your Honor, that we recognize that has imperfect results. The problem that NIH was addressing is that these words were currently used, and unless
So we would have to agree that categorically these words are so often off topic that it's permissible for NIH to do it, because you're not adjusting topic by topic on your posts.
so the question under reasonability is
They're
whether
categorically off topic. for
whether
NIH.
it's reasonably, it doesn't have to be the most reasonable interpretation, or sorry, limitation. It just has to be a reasonable limitation. And if there is,
Who came up with this list?
the social media administrators at NIH,
Do we know how they came up with it?
based on their experience reviewing the kinds of comments that were on NIH's posts.
Any guidance given to them on how much is too much? When, how often, even if it shows up a lot, it's also going to be relevant across the board for NIH policies? How- They just said which words are showing up the most and not what topics do they then compare it to what topics does NIH discuss?
So these were the words that showed up the most in commentary that was clearly off topic, where there was not even an attempt by the commenters to
How
be
did they
on
decide
topic.
it was clearly off topic is what I keep coming back to? Because I really am struggling with how tests is just clearly off topic for NIH.
I would, the comments that were being posted were using these terms, and the comments themselves were not related to the topic of the post. It's not a question of whether test itself is on or off topic. It's that the comments that they saw that were off topic were recurrently using these terms. And that's
So
why,
the keywords can be acutely on topic. That doesn't matter for your First Amendment analysis, as long as some people out there are using them, or a lot of people out there are using them in a bad way.
there's a problem that NIH is trying to address, which is off-topic comments that are using these words. And the effect of prohibiting these words might be to also filter out comments that are on topic, but under the First Amendment, we don't require tailoring if it's a limited public forum. And so the fact that occasionally this is going to be over-inclusive is not something that is required, as long as the government was reasonably attempting to address a legitimate problem. And here there was a legitimate problem of comments that were currently using these terms.
All right, thank you very much.
Thank you, Your Honors.
Ms. Krent, we'll give you 3 minutes for rebuttal. I think we've gone over our 10-minute time limits here.
Thank you, Your Honors. I just want to take a moment to be clear about the burden and the factual record in this case. The burden always rests with the government to prove the constitutionality of its conduct. So to the extent the factual record is sparse, I think that's a problem for the government. It's especially a problem for the government because it's only under the government's theory that the question of when and how these keywords were developed and exactly how much off-topic speech there might be on the comment threads becomes relevant.
You didn't ask for any of that information. You were happy to proceed on a stipulated record and not dispute their claims of overwhelming off-topic comments. That's where I'm struggling. This is, you all agreed to do this. This isn't, a contested summary judgment record. This is.
That's right. And I
Your
think
agreement to come forward on this record and say, fine, we'll take as given that these are overwhelming majority of comments.
Well, I think my answer to you, Judge, is yes and no. Yes, it is a stipulated record, but no, the plaintiffs have never conceded that comments about animal testing are the most prevalent form of off-topic speech on the threads. I think if you read the briefs at the district court level, you will see that very clear. Even the district court's own opinion makes very clear that we argue that there are that there are copious amounts of on-topic speech about animal testing, and that there's nothing unique about criticism of animal testing that could justify the government's single-minded focus on animal testing as an off-topic subject matter. I also want to be clear that the district court didn't make any factual findings to say that criticism of animal testing or even comments about animal testing are the most prevalent form of off-topic speech. I think the district court said there were large amounts of off-topic speech, and that might justify the decision here, but I don't think that's enough. And in fact, at summary judgment before the district court, we explained that if the NIH's benign motive is relevant, then you would have to look into questions about what decisions the NIH made, what information it was relying on. But to take a step back, I don't think those facts are actually needed to determine what course this case should take next. That's because the NIH's scheme here is by design so over-inclusive that it allows the government to talk about animal testing while silencing its critics on that very subject. And when it does that, it targets criticism in the very words it chooses to include in keyword blocking. On this theory, the NIH could decide to ban all mention of Biden or Trump in the run-up to the election, saying that they have nothing to do with the very specific posts, even mention of Dr. Fauci, who was an important figure in leading the public health effort around COVID-19. And I don't think the problems stop with the NIH, right? Because you could have a school board that wants to ban mention of phrases like CRT or Black Lives Matter. You could have the State Department banning criticism of its policy on Israel and Gaza, even as it is providing updates on its own conduct with respect to that with respect to that action. That's what makes the keyword blocking here so dangerous. And that's exactly why we'd ask this court to reverse the district
Do you
court.
have any knowledge, and I guess it may just not be on the record, of how facile these keyword blocking techniques are? Can they be done post by post as opposed to categorically across pages? How easily can they be turned on and off?
Right now, I don't believe they can be done post by post. The joint stipulation makes clear that these apply to the page in its entirety, not to a specific post. I don't have the specific site in the joint stipulation, but I believe all you have to do is log on to your settings and add or subtract the words that you want blocked. So it would be simple for the NIH to kind of update that list. And the fact that the NIH has shown no interest in doing that it continues to block these terms indefinitely, I think is further evidence that it is not enforcing an off-topic rule, certainly not in any even-minded way, but is instead targeting criticism of animal testing and doing so because it's criticism of the agency. I really think those are the stakes of this case. There are other tools the NIH could have used if it wanted to go about targeting off-topic speech, repetitive speech, bot speech. But what it's done instead is target a particular form of criticism against the agency, and that violates the First Amendment.
There were a certain group that kept using bot speech and kept repeating the same
Well, I think
flat earth, flat earth, flat earth.
I think
They then ban flat earth.
Well, I think then what they could do is use content neutral means to moderate that speech. So it could ban bot speech for all speakers.
That's what I'm asking is okay, so they have a policy that no bot speech, but how do they enforce that?
Well, Your Honor, I think it's telling that they haven't even tried, right?
I'm asking you, how do you do, it doesn't help me for you to give me an example that actually doesn't work in the real world other than to sort of shake your fingers and say no bot speech.
Well, I do think it would have an effect in two respects. The first is that having that rule could deter some of the conduct. The fact that the NIH hasn't tried to.
Not going to deter robots.
Well, it might deter the people that are creating the bots that are being sent.
I'm dubious about that.
The NIH could also use manual review, and we don't
Okay,
know.
so the world is manual review. Or, they already have the repetitive posts in their guidelines. So they can do that, and then they can have, it sounds to me again like your position at the end of the day is manual review or nothing.
I don't think it's or nothing. I think at the end of the day, our position is that keyword blocking cannot be used.
What's the other alternative?
Well, for example, if the bots had a similar username, I suppose at that point you might be able to use a keyword filter to target those bots. It might also be that manual review is much more efficient when you're looking at bot speech rather than looking at the content of a particular post to enforce an off-topic rule. So I don't think the NIH's hands are tied. It might be that moderation is not a completely cost-free benefit to the NIH's comment threads, right? This court has always said that you cannot sacrifice speech just at the altar of efficiency. So there may be.
But if the consequences, if you push government into a position where it just has to have no comments, turn off the comment option on all of its posts. It's hard to see how that's a pro-speech outcome, but if that's the corner they're backed into because they don't have resources, it's unworkable to have every government agency employing armies and armies of people to manually review. And by the way, they must have these perfect First Amendment, not too discretionary standards for every review. If that's just not tenable, then they're just gonna have to turn off comment threads.
I understand.
You're gonna be worse off.
I understand the concern about perfect enforcement and negative results that might lead from that. It's possible that the NIH chooses to actually limit its forum by enforcing its rules in a way that does suppress more speech. It's possible that it turns
It's
off.
not suppressing speech if it decides not to have comments.
Right, it's possible.
Clear, that's not suppressing speech. That's their choice.
That's right. And it could be their choice to close the comment threads. And I do think that would be a bad outcome for speech. But what I think would be a worse outcome is to allow a government agency to hold open a comment thread that looks to everyone else like it's open for discussion. But behind the scenes, they're using kind of the invisible hand of the government to pluck out criticism and to tilt and distort the field of public debate in these digital public spaces. I think that is the worst case scenario for free speech, and I think the First Amendment prohibits it.
Thank you very much,
Thank you.
Counsel. The case is submitted.
Case number 23-1248, Coalition for Renewable Natural Gas Petitioner versus Environmental Protection Agency. Mr. Ellis for the petitioner, Ms. Kimball for the respondent, statutory authority for the biogas regulations, Mr. Leporo for the respondent, arbitrary and capricious and procedural challenges.
May it please the court, Jonathan Ellis on behalf of the Coalition for Renewable Natural Gas. The renewable fuel standard is unique among EPA's regulatory programs. Rather than command and control, the RFS is designed to act as a market forcing mechanism to incentivize the creation of renewable fuels and the environmental benefits that come with them. For a decade after EPA permitted renewable natural gas to participate in that program, the design worked. The creation of RNG increased fourfold on the back of substantial investments by the regulated community. Today, transportation fuel created from RNG accounts for nearly all cellulosic biofuels created in the RNG program or RFS program, and there have been no reported incidents of fraud. We're here this morning because several unlawful changes to the biogas reforms threaten that success. In the biogas reforms, EPA almost completely rewrote the regulatory program for RNG. It rewrote the rules for how parties register, test, record, and report their activities, and how they create and separate the credits for renewable fuels, called RINs, all to guard against the potential for fraud. Now, to be clear, to the extent those requirements roughly align the production and regulation of RNG with other renewable fuels, we don't take issue with them. Importantly, that means that includes the use of the EPA's moderated transaction system for RINs created from RNG, and replacing the need for EPA to review a complicated set of related contracts to verify the proper creation and retirement of RINs for RNG. In several respects, however, the biogas reforms went well beyond the regulatory requirements that EPA imposes on the creation of other renewable fuels and beyond any reasonable fraud protective measures. Although I'm happy to address any aspect of our challenge this morning, I'd like to focus the court on three components of the biogas reforms that we find most problematic. First, the direct regulation of biogas producers. Second, the prescriptive continuous measurement requirements for biogas producers and RNG producers. And third, the annual pipeline quality testing requirements. First, the direct regulation of biogas producers. Now, EPA claims authority for the direct regulation of these entities based on their responsibility and obligation under Section 02A1 to ensure that RFS volume obligations are met. But 02A3 tells EPA specifically who is to be the subject of compliance regulations under that provision. It is the obligated parties, the refiners, the distributors, importers, and blenders of transportation fuel, not dairy farmers, in cities and counties operating landfills and municipal wastewater facilities.
So if the statute didn't have clause 3, would you agree that clause 1, which essentially says EPA shall ensure that the renewable fuel targets are met, would that naturally be read to include the ability to regulate anybody in the production chain, including biogas producers?
I still think we have concerns about how far that goes. It's a vague term, and I don't think that you could read that to reach back the entire production chain all the way. I take it on EPA's reading to the trash I put outside my door that's eventually going to be in the production chain here. But I don't think that's really an issue here because of the 02A3, which tells EPA exactly who it's supposed to register to regulate there.
Absolutely. So, I mean, the idea is that it at least seems to me that you're asking us to read subclause 3 as creating a limitation on power. And I'm just wondering how you get there with the words that it uses. So it says shall contain. It does not say shall only contain, shall regulate these parties but not others. So why should we read it as a limitation on EPA's otherwise applicable?
Yeah, so two answers to that, Your Honor. The first is I think, this is the idea that it has to be it's a floor, or it's a floor, not a ceiling. And I don't think that can work. I mean, what the provision goes on to say, is that it shall contain compliance provisions applicable to refiners, blenders, distributors, and importers, quote, as appropriate. And so it doesn't even require EPA to regulate those entities. So the idea that it is a floor doesn't make a great deal of sense. The second thing I'd point out is that I don't think that this court's decision in heating AC and refrigeration distributors dealt with a very similar problem there. And in fact, it dealt with the same word, ensure. And what the court said there was not that the separate provisions in the act really were used in exclusive language, but that they told EPA there how to ensure, and there was that HFCs did not exceed a cap on production. And in the light of that, in light of that specific direction to EPA about how to ensure, they couldn't rely on the vague term, the vague of ensure, to go beyond that and implement complementary compliance regulations. Now, EPA.
So under that reading, are they not allowed to regulate auditors?
So under that, I think they have additional authority under 05, Your Honor. That's the provision that allows them and requires them to create a credits program. And so I think there they have regulated, long regulated RNG producers, for example, who are generating the RINs, and other entities who are separating the RINs, who are engaged and interacting with those credits. They haven't relied on that authority here, and for good reason, because in the biogas reforms, they require only RNG producers to create those RINs, and they do not allow biogas
But
producers to
RNG
do
producers
so.
aren't on this list either, so they can't regulate them. They can't impose any compliance provisions on them,
So
apart from the RIN process. Is that your position?
that's right. I mean, I think apart from the RIN process, when they're touching the RIN process, when they're creating this RIN process, that may be true. And there may be, there may be other places where they can identify authority, but this is not the.
The regulation you're challenging here doesn't implicate, it's hard to figure out, since RINs drive this whole process, how they are not implicated at every stage just as well, at least at this end of the entire process. I'm not talking about the consumer or the gas pump.
Right.
But it's hard. It seems like an awfully difficult line to say that what they did here was a compliance provision, and the compliance provisions can't include compliance with the RIN process.
So I think that if they're going to rely on 05, and they have not here, they need to tie it to the RIN process. They haven't tried to do that. And I think it would be, I think there has to be a line.
That RIN documentation, I mean, it's not only sort of the trading system it creates, but it is a way of tracking the fuel as it goes through the process to make sure, because things get commingled in pipelines, and they need to make sure that what comes out of the landfill and goes into pipes into the renewable gas producer and comes out at the end of another pipeline is the renewable fuel and wasn't mixed with something else. And so they have to, part of the way you have to have compliance provisions overlap with anyone who's involved in the RIN generation process, so they can make sure, they can ensure the requirements, the production of the required amounts of renewable fuel are met. It seems to me like a very artificial distinction.
So 2 points on that, Your Honor. Again, the biogas producers are not involved in the RIN generation program process. They are not permitted to generate
renewable fuel
RINs.
producers are, and they're not on the list either.
Correct, and that's why we are not disputing the regulations here of the RNG producers who create the RINs.
But they're not on the list. There's no producers on this list.
Right, so I'll try this again, because I was not unclear, I think. There's two sources of authority we're pointing to here, right? We are identify here. One is O2A3. So the compliance regulations go to the obligated parties. That's the only, that O2AI, one is the only authority they've relied on here. The other is O5. That's a separate bucket of authority. They have not invoked that here, and they haven't attempted to, but if they did, we think that they could justify the regulations of the RNG producers, because they have to regulate and they have to provide for the creation of the RINs, and the RNG producers are creating
No, but
those
you're
RINs.
requiring us to make a reading that would say they can only do it under that provision. And they cannot, maybe they could do it all there, but they cannot invoke the 2A1 authority at all as to renewable, under your reading, because I know you're a step earlier on the biogas producers, but
Right.
producers are not on the list in section 3 or Romanet 3. They're
So
not
they
on the
can't
list.
rely, I
They
think
can't
that's
be
right.
done it, but if that's needed to ensure that the amount of fuel and only renewable fuel that's properly labeled as such gets through, and say for some reason they didn't need to do it as part of the RIN process, you'd say they just can't do it under here.
I'd say they could do it under 05. I'm not sure why it matters which one they invoke. I think they can regulate. We're not disputing that they can and have regulate RNG producers. And I think there's an important point here, because going to your sort of how do they do this point, this is what they've done since the initiation, the creation of the RFS program. They have always regulated the renewable fuel producer. And they've done that under 05. They've done that in the creation of the RINs. And they have never reached back to the feedstock producer. And outside of the biogas reforms, they still do not. And so you ask, you say they have to be able to ensure that the biogas is created, or the renewable fuel is created from a renewable biomass. And I agree with you, Your Honor, but they've done that elsewhere by regulating the renewable fuel producer and requiring that entity, who is actually engaged in the creation of renewable fuels. Biogas producers are dairy farmers and landfills and counties and cities who are not engaged in this process.
Well, do they not? Go ahead.
Under the prior regime, the biogas producers were certainly at least indirectly affected, right? They had to provide information or hopefully some kind of assurance to the RNG producers about what they're providing them, didn't they?
So in the prior regime, whoever was going to generate the RIN had to provide that documentation. And yes, in instances, they would ask for the biogas producer to help them, the contract partner, right, to actually provide that. But
so can you tell us why? I understand it's much more burdensome now, but why is it materially different now? Because I think on EPA's telling, they're still saying it is entirely voluntary whether you want to be a biogas producer that provides biogas for the RFS program. And so when you do, you're going to have to now register and provide all of this information. Before you were providing some lesser information to others, now just provide it directly to the EPA.
Right. So I think the voluntary nature of this actually cuts against them in a fundamental way. Right. So it's true. They had to provide some information. Biogas producers, these landfills and cities and counties had to provide some documentation to the RNG producer. But EPA's own numbers indicate that they have increased the compliance costs on those landfills, dairy farmers, 59 times in this regulation. That's a meaningful burden for somebody who's not in the business of renewable fuel production. And the reason that matters, the reason that cuts against EPA and not for them, is that this is the market forcing mechanism. This is the whole program is designed to incentivize the creation of renewable fuels. If the biogas is not collected from the landfills and the dairy farms and sent to be this productive use, then it's going to be used for flaring. It's going to go into the atmosphere as a potent natural gas.
That sounds more like a policy argument, because you have said once they choose to be part of the renewable fuel production system, that's the only time they have to comply with these regulations, which are ensuring it's the appropriate, fuel stock or feedstock, whatever you call it, waste stock. It's an appropriate source for renewable fuel. That's what they're obligated to do, only if they choose to. So it's only if they choose to get into this system that they have to do it.
Sure. So I think it is relevant.
Policy concern is it's going to dissuade people, then that's on EPA.
So I think it is relevant to the statutory question, because I think that we have to read the statute in a way that complies with Congress's goals, and that is certainly one of the goals. But we also have an arbitrary capricious challenge here, Your Honor. And I think it's important to note that this is unreasonable burden, and they don't impose it on any other feedstock producer. So they say we can only get this information from the biogas producer. We can only check the renewable biomass with them, but that's not what they do for biodiesel. Biodiesel has a soybean farmer, has a soybean oil crusher, and then has a biodiesel producer who takes that soybean oil and turns it into a renewable diesel or biodiesel. And they don't regulate the soybean oil crusher. They don't regulate the soybean farmer. They still manage to figure out that is
the only source.
I'm sorry?
Are soybeans the only source for that biodiesel?
For renewable diesel, I believe the soybeans are the only source. It's not true for ethanol.
No, but it's corn. But I think there's lots of different feedstocks that can be used, that waste that will produce biogas in a generic sense. There's only certain types of that they want to come into the system, and that's why they have to have this regulation to make sure it's the right type of biogas producer that's essentially hooking up to the renewable fuel producer.
So I'm not sure that explains why you couldn't ask for that documentation from the renewable fuel producer. They suggest that they can't.
Is it any better if EPA obligates the renewable fuel producer to require the biogas producer to provide this information? How is that any less of a burden on the.
Because it
biogas
doesn't
producer.
include monthly reporting mechanisms. It doesn't include annual audits. It doesn't include 3-year engineering reviews. It doesn't include a liability for messing up those compliances. It doesn't include continuous measuring, prescriptive requirements for taking out your
But
gas
there's no
analyzers and
question.
installing.
But I thought you just said, there's no question that whatever information EPA thinks it needs to ensure that it's getting the right feedstock into the system, it could require the natural gas producer, the renewable gas producer to demand that same information from the biogas producer.
It require them to get the documentation that
It
that's
would
true.
require all that same, and that documentation could be exactly what they're asking for here.
Well, I think we'd be back here if they tried to impose
But you
the
wouldn't have
exact
your
same
statutory-
burdens.
You wouldn't have your statutory argument.
We may not. I think, if there are ways in which they're trying to circumvent the limits on their authority by, through
Compliance
someone
provisions
else.
Under Rule 3, under Romanet 3 here, can be requiring these parties to impose identical burdens on biogas producers.
I don't think,
If they want to play.
I think the obligated parties need to verify that they have met the volume obligations. I think EPA can require the obligated parties to
This
do
isn't
that.
just.
And
this is compliance
05,
this is 3 here is not just about meeting your fuel obligations. It's about meeting your fuel obligations with the right stuff and the right
Sure.
process stuff. That's what the
Absolutely.
compliance provisions are. And so I'm back to saying, if they could say to you, renewable fuel producer, don't let anything into your pipes and don't transport anything down to a pipeline or a truck or whatever you're using that hasn't first been verified by a biogas producer who does testing, auditing, and all the other compliance provisions you were referencing. If they can do that, then what's the difference between just doing it directly? rather than indirectly?
they did that before. And what EPA admits, their own numbers suggest that the burden they're imposing on biogas producers has increased 59-fold.
I
because of
understand
the way
that,
they've
but
done
what
that.
I'm saying is, if EPA requires the renewable fuel producers to impose that exact same burden that they're just imposing directly, there's no difference.
Again, that's a different situation. We may be back with the statutory argument about them trying to circumvent the limits on their authority. But that's not the situation we have here. They are imposing direct regulation. And if you look at, compare the two Regulus programs, so subpart M of the regulations is the renewable fuel standard programs. That's the normal way that they regulate and that they comply and they ensure that renewable biomass is met and they ensure that it's used as transportation. It doesn't directly regulate the feedstock producers. It just doesn't. It doesn't have a section for it. They created a whole new section in Part E that has specific provisions that are onerous requirements that are going directly to the biogas producers and imposing liability directly on them. And I think that's a meaningful difference here. Meaningful difference from the statutory perspective, and I think it's a meaningful difference from the arbitrary and capricious perspective. I mean, and under the
How is
APA,
it
they've.
imposed if they opt in?
I'm sorry?
How is it imposed if they opt in?
It is imposed if they want to participate in the
They
program.
choose to participate, here's the rules of this process, and they have to be these rules to meet Congress's goals. That's the EPA's position. You make the point, maybe it's right, that people, they're all going to say, forget it, too much trouble, I'm going to do something else with this waste, or just let it sit here or burn it off or whatever. And that will be a huge problem for EPA to deal with, but it doesn't become imposed when you simply say, if you wish to participate in this program and make a lot of money for that waste that's otherwise sitting there, there are requirements to make sure it's being done right.
So I think in a market incentivizing program, a market forcing program, that does make a difference. But even if you disagree with me on the statutory
It only makes a
analysis.
difference if it actually does disincentivize, which is just an empirical question we don't have, and that's a policy call for EPA.
So, right, but when you get to arbitrary capricious, what are the fundamental principles of the APA is explaining at a minimum and providing a reasonable explanation why you're treating similar situated entities differently. And I think that's a problem for EPA here. I think that's a problem that they don't actually regulate feedstock producers under any other part of this program. This is the only one. And I don't think that they have faced up to that. And I don't think they have provided a reasonable explanation about why that is.
Well, I don't think they're taking the position that this is the only way they can get the information. They're just saying it's the best in the context of this program.
But
And
why isn't it
is
the best
something
elsewhere,
they-
right? I mean, even if you look to the end of this program. So let's step out.
Arbitrary and capricious rule that says agencies have to go in, jump in with both feet. They can't start with one area and then work into other areas.
True enough.
That's pretty well settled.
But they've got to explain why they're treating it differently. it may be that that it would be sufficient to explain why this is the one we're going to choose first, because this is there's been fraud, but there hasn't been any
We're
incidents of
concerned
reported
about
incidents of fraud
It's
here.
expanding, it's growing, it's gotten a lot more complicated. We're concerned about fraud. If we thought that were a sufficient explanation, I know you think it isn't, then that would meet this need to explain why they're starting here.
If you think that's a reasonable explanation for why they're treating bio producers differently, I actually don't think they've said that. I think what they said is we're going to throw out the old system for that reason and implement a new system, not what we're going to go beyond what we've done elsewhere for those reasons. But if you think they said that, I disagree with that. And if you think that's sufficient, then obviously we lose that angle on the APA challenge. I don't think that is sufficient because I don't think that they said that, and I don't think that they have actually justified that.
You think they were asked to, and therefore required to explicitly acknowledge that they were taking a different approach here than in some of the other programs?
And then
explain
justify that.
explicitly? Okay.
Yes.
Can I ask you about the third argument you said? I know we've been stuck on the first.
Yes.
The pipeline specification. I actually think the best way would be if you could just tell us what the crux of that argument is in your view.
Sure. So among the biogas reforms, what they've required is annual testing by RNG producers of the RNG, the renewable natural gas that's interchangeable with fossil natural gas that they're injecting into the pipeline, into commercial pipelines. What they said in the rulemaking, they gave two reasons for that. The one is fuel quality. They need to ensure the fuel quality of the RNG. And two, they need to ensure that the RNG can be injected into the pipeline. Before this court, I take them to have abandoned the first rationale and focus only on the pipeline specification rationale. The problem for that is twofold. First, they can't explain why we need to provide annual testing that we meet the pipeline specification when they also require RNG producers to prove that in fact the RNG was injected into a commercial pipeline, a regulated commercial pipeline, and RIN separators to also prove that they withdrew the RNG from the pipeline. The statutory requirement here is that RNG is used as a transportation fuel. And if it was injected into the pipeline, as a matter of fact, and it was withdrawn from the pipeline, as a matter of fact, and used as transportation fuel, it's lost on me why we need to also prove that it could have been injected into the pipeline. And one more point on that, Your Honor. If you look at the regulations, they on their face go beyond just the pipeline specifications. They also allow EPA to request any other information, any other testing as a condition of registration.
So just on the first bit of that, it does seem like the problem you're complaining about, I guess, is redundancy. The pipeline, of course, has already tested if they're going to allow our gas in. So why do we need to retest and send the results to the EPA? And it just doesn't seem that unreasonable to me for the EPA to ask you to send that testing result so it can have its own documentation of what's going into the pipelines itself.
But the statutory requirement is that it be used as a transportation fuel, not that it can go in a commercial pipeline. The regulatory requirement is that it can go into a pipeline. And so we're 2 steps removed from the statute at this point, and we already have proven twice over that it did go into a pipeline. And so beyond that, I think it's hard to explain, and it's just, I think, unreasonable and arbitrary to impose unnecessary burdens on RNG producers to do that testing and to report it.
So the second thing they say in responding to comments is that both so it can get into the pipeline and so that the RNG can be used to produce and be used as transportation fuel consistent with CAA and EPA regulatory requirements.
Yes.
Now, that's the argument that you're taking them to have abandoned.
So I'm not in the response to in the final rule. They also said we're balancing our requirements to sort of measure fuel quality, ensure fuel quality. This piece about whether is it possible to be used as a transportation fuel? I'm not sure actually. I guess if they're relying on that here or not. But I would point out that the RIN separator has to prove.
So that's the question. Wouldn't that be a justification that isn't trying to impose a fuel quality standard? Nor is it just saying, give us the results of your pipeline test. It's trying to ensure that it can be used as a transportation fuel. So we need to test for these other components on a uniform basis.
So I think no for 2 reasons. First is the redundancy point already. It's not going into the pipeline if it can't. And I guess the other redundancy point is that the RIN separator has to document before they can separate the RIN that it was actually used as transportation fuel, that it was withdrawn from the pipeline and then actually used, compressed to CNG or LNG, and then used as transportation fuel. So we've got the same problem where we've got documentation that it was used as transportation fuel. That's the statutory requirement. And we're imposing additional obligations beyond that for no apparent reason.
Well, it seems like what you'd have to say it's been properly injected into the pipeline and then properly used as transportation fuel. And the point of EPA asking for this verification is to verify. And now you think the concerns about fraud are made up, but if they had some basis for that, again, they're just asking for maybe redundant verification.
So the concerns about fraud here have nothing to do with using natural, as far as I know, and nothing in the record about using natural gas that is not capable of being used as transportation fuel. The concerns about fraud are mixing fossil natural gas and renewable natural gas, or in some cases, they say mixing fossil natural gas with biogas. That latter makes no sense at all, Your Honors. I mean, biogas is about 50% methane. Fossil natural gas is about 90 or plus. There's no basis to think that would happen.
Biogas is not going to qualify. They don't want to mix with that at the pipeline stage.
I'm sorry?
Just unrefined biogas, which could be from any feedstock,
Sure.
is not. It's not, if they don't want it mixed with that, there's a reason they've limited the feedstock.
Absolutely, Your Honor. I think that's right. I mean, my point was only that there's no legitimate concern, no plausible concern that there are parties out there mixing fossil natural gas with untreated, with raw
The
biogas.
rationale is these RINs are really, really, really valuable relative to the fuel itself even, let alone the waste that's sitting out there. And so people are going to have incentives to bend the rules and try to sneak other forms of gas to get mixed in here. And so we're not just going to leave it to the pipeline. Congress told us to do the insuring, and so we're going to insure up front, and we're going to insure on the exit end. I'm still having trouble understanding why that's arbitrary and capricious.
Because that's the situation across the renewable fuel program. That's the situation for all renewable fuels. We don't
If they
object.
regulated everybody, you wouldn't have any objection. It's simply because they've only picked on the biogas.
So if they regulate everyone, if they regulate or they explain why they were doing it, except people treating similarly situated entities differently, obviously I wouldn't have that argument. Now, I would still have the statutory argument, Your Honor, that I think that they have regulated or restricted RIN generation to the RNG producer and beyond.
Right, but so this is the same argument then as you made before. It's not that it's inherently arbitrary and capricious to check on the way in and check on the way out. It's that you just can't do it for one renewable fuel and not others. That's your argument.
I also think it's unnecessary. They haven't shown the basis for that. They pointed to the concern about potential fraud, but there have been no recorded incidents of fraud. You can go look at, the rules cites their enforcement page, and you can go look at the cases on there. None of them have anything to do with biogas. There are cases with regard to other renewable fuels, but none have to do with renewable natural gas. And so I think if you were going to take a rational approach to where we're going to implement these additional fraud protective measures, you would do it in a case where they're in an instance in an industry where there has been reported incidents of fraud, not here where they admit there has been no reported incidents of fraud.
I just had one last question. You complain about the compliance date, but they say it's the date you asked for?
So we've complained about two dates, Your Honor, both the July 1 date, which we did object to, and the January 1, 2025 date. I think importantly on that point, we objected to that along with a bunch of other onerous obligations they impose, including the prescriptive continuous measurement requirements that we haven't had a chance to talk about this morning. They didn't change those and they imposed additional obligations. I think that's what makes the January 1 date problematic.
You say when you suggested January 1, 2025, that that's conditioned on you not having these onerous obligations, or that you think that's an appropriate compliance date?
I think what we said is at least January 1, 2025. I don't know that we went to the specifics to say, and everything we say here, in our other comments, we assume that you would take some.
Why are you not stopped from challenging it now?
I'm sorry?
Why are you not stopped from challenging it now?
Because
you said at least January 1. They said, fine, we'll give you January 1.
Because the premise of our request for January 1 of at least January 21 of 2025.
At least means that it'll work for me. So yeah.
I think
The premise was that we have to get everything else we want to.
I think we've got to there are some, the continuous measurement requirements are a particular problem here. There are
You
others,
didn't
but
make that explicit when you said at least January 1, 2020.
I do not believe we made that explicit. I'm not aware of a requirement to do that.
Okay. Thank you very much.
Thank you,
We'll
Your
give you a
Honor.
few minutes for rebuttal.
Thank you.
Kimball, you're just addressing statutory authority, is that right?
That's correct, Your Honor. May it please the court, I'm Department of Justice Trial Attorney Kimmery Kimball here today on behalf of EPA. EPA has a statutory mandate under 42 USC 754502A1 to promulgate regulations that ensure transportation fuel sold or introduced into commerce in the United States contains the requisite amount of renewable fuel. And the statute further provides that renewable fuel is only fuel coming from qualifying biomass. Therefore, the statute requires EPA to ensure that renewable fuel actually does come from that biomass.
So if you're right, why isn't subsection 3 superfluous?
I'm sorry, why isn't subsection 3 what?
What is the purpose of O2A3?
O2A3.
O2A31 on your reading? Why isn't that superfluous?
Romanet 3 is not, I'm sorry, O2.
Sorry, the provision that says the regulation shall contain compliance provisions applicable to refineries, blenders, distributors, and importers, so forth. Okay, I've been thinking of that as clause 3. Why isn't that superfluous if EPA can also regulate other entities?
Because in Romanet 3, what Congress said was you have to ensure that the obligated parties, that the people who have to ensure the volumes meet all of the components of the paragraph. And so EPA has interpreted that to be primarily about volumes. It's not about what the renewable fuel is. Sorry, go ahead.
As Mr. Ellis pointed out, it says, shall contain compliance provisions applicable to these obligated parties as appropriate.
Right.
And that sort of seems obvious just based on clause 1. If all it means is you can regulate those people, but you can also regulate others. I'm not sure I understood your answer.
So clause 1 doesn't specify anything about the obligated parties. It says the EPA has to ensure overall in this program that that the fuel introduced contains the requisite amount of renewable fuel, and then Congress further specified what that renewable fuel can be. In subsection 3, Congress said, when you promulgate regulations, you have to at least promulgate regulations that address this group of people.
It doesn't say at least though. It doesn't have including language.
It says it must contain, and elsewhere in the statute, when it says contain means that plus something else. So for example, in the volume requirement. Contain means whatever it's referring to plus something else. So for example, in the volume requirements, it says it must contain the requisite amount of renewable fuel, but it's not that it has to be exclusively renewable fuel. It's renewable fuel plus whatever else. Contain in this statute is used to say.
The question is not so much contain, is the compliance provisions applicable to. It's to whom compliance provisions are applicable. That's the critical language. And they list everybody but producers.
Everybody except renewable fuel producers, you mean?
Producers, period. Biogas producers or renewable fuel producers. Producers are just noticeably absent from this list. This isn't sort of a list that there's going to be 7 other things that aren't covered, an including list. It seems to say compliance provisions under the regulations under Romanet 1, the compliance provisions shall be applicable to, and then starts with refiners, flows right past producers. They knew there were producers, biogas producers and renewable fuel producers, and yet they're off the list completely.
EPA has understood those compliance provisions to be referring to the volume requirements, the volume compliance provisions. So they have to meet the specified amount of fuel in each year.
Then you agree this doesn't apply to producers?
Sorry?
Do you agree Romanet 3 is not a source authority to impose compliance provisions on renewable fuel producers?
That's correct.
It's not.
That's correct. Romanet 3 applies to obligated parties. EPA's authority to regulate renewable fuel producers comes from Romanet 1, which refers to the requirement
This cross-references. This says, regardless of the date of the regulations promulgated under Clause 1, it shall contain, those regulations in Clause 1 shall contain compliance provisions that apply to obligated parties.
Right. So Romanet 1 covers the whole program, and Romanet 3 says of all of the provisions of the regulations that you promulgate, you must have compliance provisions for the refiners, blenders, and importers. But it doesn't preclude EPA from regulating renewable fuel producers. And in the structure of
Does
this,
it preclude you from imposing compliance provisions to ensure volume requirements? Volume requirements, including that it be the right stuff statutorily on producers.
so I think those are two very different things, like volume requirements and ensuring that biomass is what is
No, it's
resulting
a
in
volume,
renewable
they care about what the volume of what. They can't just make sure some volume comes out at the end is not what this program is about. It has to be a volume of a very specific thing, and that is renewable fuel from the very feedstocks that Congress allows. So that can't possibly be that this doesn't mean compliance with the process of, making sure that we get the renewable fuels that we want and not other types of fuels, whatever the volume.
So Romanet 3 provides that the refiners, blenders, and importers have to comply with the volume requirements, which I take your point includes that it be the correct
Right,
volume.
volume of the right thing.
Right. Going back to what the renewable fuel has to contain the requisite, or has to be produced from the biomass, that's a function of Romanet 1 plus the definition of what renewable fuel is and what renewable biomass is. It's part of the structure of the statute as a whole.
I know you want to treat one as freestanding, but three says who will bear the compliance provisions for regulations promulgated under number 1. You can't sort of say that 1 is this freestanding authority if one reads 3 to say, these are the folks that shall bear the compliance provisions for regulations under Romanet 1. You can't break them apart.
Except that it only says that the compliance provisions have to contain provision. I'm sorry, it says that the regulations have to contain provisions for those entities, but it doesn't say that it exclusively contains them.
Compliance provisions that are applicable to. All right, so it's not just compliance provisions, it's as to whom they will be applicable.
Right.
And producers, you can't just have compliance provisions. They have to be applicable to these folks.
Right.
And when they list everybody who's involved in the process that they want compliance provisions to apply to, and they leave out one, and that is producers. How do we know that's just not a deliberate decision by Congress that compliance provisions for regulations under Romanet 1 will not apply to producers? They skip right over them and go right to refiners, blenders, importers, distributors.
Because there's no way to enact the rest of the statute. There's no way to ensure any of the definitions are met without also looking at the renewable fuel producers. Since the beginning of the program, EPA has regulated the renewable fuel producers because you have to
They say that
ensure.
you do that under the RIN program, not under 1 here, not under 2A1.
EPA has never claimed authority under the RIN provision as its exclusive authority to regulate the renewable fuel producers. EPA has always claimed that authority under Romanet 1.
Is there any case that says you have it?
I'm sorry, any cases where what?
You may have claimed it. Has any case held that you have it?
I'm not aware of any case in which that's been challenged and come to a decision.
Is there anybody off this list that would be relevant for compliance provisions to ensure volume requirements other than producers? Did they leave anyone else off this list? An illustrative list, or you think this is an exhaustive list?
I think that Romanet 3 sets a floor for who the compliance provisions, meaning the volume requirements, apply to.
Who else would it be? Producers? Who else?
Well, so
I mean, floor, so that usually assumes there's more on top. So it would be who else?
So
Producers?
in renewable fuel production, there are renewable fuel producers. Under the current system, there are also biointermediate producers. There are
Producers. They may have different producing jobs, but producers.
That's correct.
It's really weird for Congress to set a floor that lists everybody that they want to cover except one.
But the rest of the statute and the definition of renewable fuel and the requirement that EPA ensure that that fuel includes renewable fuel and that renewable fuel is produced from qualifying biomass requires EPA to regulate renewable fuel producers. If it were the case that EPA could only regulate the obligated parties, refiners, blenders, and importers, then there would have been no reason to include any requirements on biogas at all because biogas never gets to a refiner. Biogas is put onto a renewable natural gas pipeline. It's taken off by a compressed natural gas producer and compressed it directly into what goes into a natural fuel vehicle. There's no step in that process.
Trying to get you to answer the question, what their theory is, it's fine to regulate renewable fuel producers as part of the RIN authority, right? You can't get the RIN won't attach unless you do A, B, C, D, and E. So that's how you get to do renewable fuel producers. What's wrong with that?
There's nothing in the statutory text that limits EPA's authority in that manner. There's nothing in 05 that says EPA can only regulate the RIN producer. The 05 doesn't refer to the RIN producer in any way.
Is there any way in which it is not statutorily sufficient to do renewable fuel producer regulation under other statutory authorities and not under 3? Can the program work if you can regulate renewable fuel producers under other statutory authority?
The Romanet 1 is the
Under other statutory authority, the RIN program.
Well, the RIN program requires EPA to set up this credit program, but there's nothing in that provision that says who EPA regulates under that.
Right, there's no limitations on anyone who's in the RIN program, and renewable fuel producers are part of the RIN program, right?
Hey, renewable fuel producers are part of the RIN program.
So
It's
you
true.
can definitely regulate them there. I'm just asking why it wouldn't be sufficient to say the RIN program is your sufficient authority for regulating renewable gas producers, renewable fuel producers there. And then the extent you have regulations under Romanet 1, those can only be applied to the later steps in the process, the refiners, not down the line.
That's not how EPA has conceptualized the statute.
I'm asking whether the scheme, because you keep going, the scheme won't work. I'm asking whether the scheme will work.
Well, I think it's difficult to say because EPA has not conceptualized its authority in that manner. I will say though, if it
The
is.
answer to me kept being that the program won't work if it's read that way, but it doesn't seem like you can say that actually.
Well, I don't think I can say whether or not EPA has authority under 05 to regulate renewable fuel in a sufficient manner in order to ensure that it contains the requisite amount of biomass, because EPA didn't rely on that authority in this rulemaking, and I don't know to what extent it has considered whether the RIN program itself is sufficient to provide statutory authority.
This is the first time EPA has ever used this authority under 2A1 or 1 and 3 to regulate producers, renewable fuel producers.
So just under 1, but it has always regulated producers under that statutory provision. EPA has always considered that to be the source of its authority to regulate renewable fuel producers.
And so you read 3 as not limiting, not words of limitation because?
Because it just says that EPA must, or EPA should put forward regulations that contain compliance provisions for that group. But that's not.
It doesn't say some regulations, it says regulations promulgated under clause 1.
Right, but it says.
It's just some of the regulations, not all the regulations.
That sets the floor for what regulations they provide. EPA had to at least provide regulations that set compliance provisions on the obligated parties. But that through the statutory framework as a whole, EPA has to be able to regulate the renewable fuel producer and has to be able to regulate, for biogas specifically, that has to include the ability to regulate biogas, because biogas is unique in this program in that the biogas producer gives the renewable gas producer just biogas and not the biomass itself. And so the renewable gas producer doesn't see the biomass at any point. So EPA has to be able to regulate the biogas producer in order to comply with its obligation to ensure that the renewable fuel came from the requisite biomass.
Thank you very much, Nelson.
May it please the court. My name is Alex Papuro, appearing on behalf of the United States Environmental Protection Agency. I'll be addressing the remaining issues. To address a point raised by petitioner today, petitioner claims that EPA's regulation of biogas producers is arbitrary because they're like, EPA is not doing things like they're doing in other aspects of the program. What petitioner ignores is that biogas producers and RNG generated from biogas is different than other aspects of the program. Let's take an example that we referenced in our brief. Petitioner claims that EPA is attempting to regulate a feedstock provider here. That's not the case. In the example provided in the brief, petitioner explained that this would be like trying to regulate the corn farmer. Whereas today, petitioner is explaining that the regulation here is different because EPA is only supposed to regulate the party that converts the feedstock into renewable fuel. But here there's an extra step in the process. The feedstock goes to a biogas producer. The biogas producer oversees the digestion of that feedstock, which turns into biogas and then later has to be upgraded into renewable natural gas.
Counsel, that might be a good explanation. It's the explanation on page 42 of your brief, but there's not a citation to the record. And so I think what you need to tell us is a reason why this explanation wasn't either somewhere in the rulemaking where EPA gave the explanation you just did, or a reason EPA wasn't required to give that explanation. And it's, are you leaning towards the latter, or is there something in the record you can point us to?
EPA provided, we believe EPA provided a reasonable explanation here for regulating biogas producers. The difference between the other aspects of the program, I don't have a record site ready today, but EPA explained in other aspects of the record that it's regulating biogas producers because they directly oversee the production of biogas from feedstock. For example, at Joint Appendix 547 to 49, in the response to comments, EPA explains that biogas producers are directly responsible for overseeing the generation of biogas from renewable feedstock. And that is the reason why EPA needs to directly oversee them in this program and enforce compliance provisions, because biogas producers are the party that's responsible for the information that determines whether the renewable natural gas that is used as the source of fuel in this program derives from a renewable source.
Yeah, I guess the question I'm struggling with is that's, as you've suggested, is different from whether there was a compare and contrast done explicitly by the agency. And, you know, there might be, maybe it wasn't teed up well enough for EPA. I don't have a, you know, the answer to that either. But it seems to me you need to have an explanation of why you weren't required to give a comparison, and this explanation of why you can regulate biogas producers, but not corn farmers. Why you weren't required to give that explanation.
To the extent that the court's asking whether EPA has the authority to address that, to regulate the corn farmer.
Mr. Ellis's argument proceeded as if a huge issue in this rulemaking was, why are you regulating the biogas producer but not the corn farmer? And it seems undisputed there was no explanation why you're regulating the biogas producer and not the corn farmer. And then if everything I've said so far is right, that would be a big problem for you.
We don't agree, Your Honor. We don't know that the requirements here require EPA to provide a compare and contrast with other elements of the program. We believe EPA is required to provide a reasonable explanation for regulating the parties that are at issue in this rulemaking, and EPA did so. It explained that biogas producers oversee the production of biogas from feedstock. It explained that these parties do provide information that EPA needs to determine that the RINs generated from renewable fuels are provided here.
But if every biofuel producer or process is going to have the same question of we got to ensure it's the appropriate source. Why didn't EPA have to say why it was picking on biogas?
EPA did explain here that biogas is a complicated program, that it's one step removed from the feedstock here, and that the reason for implementing these
Is it
regulations.
more complicated than the other biofuels?
Yes, Your Honor.
Why?
Because the other biofuels are that when you process, let's say, corn into fuel ethanol, that's one step. And when you process the corn, you get the ethanol that's used as fuel. That party, as petitioner concedes, is regulated because they're the one producing the fuel from the feedstock. Here, the party that's producing the fuel, the RNG producer, who is the RIN generator under this program, does not oversee the digestion from where the feedstock originally came from. There, that's the biogas producer. And in some cases, those may be the same party, but in cases where they're a separate party, the way EPA would previously oversee them was to have the party submit contract information and reports that it obtained from the downstream party. But here, EPA has determined that it's appropriate to obtain feedstock, obtain the information directly from the biogas producer because they're the ones that oversee it. They're the ones that need to comply with the requirements and provide that information.
Oversee what?
Oversee the production of biogas from feedstock. So they're not simply selling trash to a renewable fuel producer and they're the ones that turn it into fuel. They actually oversee a conversion process that later goes to an RNG producer. An RNG producer who gets the biogas can't take the biogas and say, this comes from a waste product or corn or something else. The party that oversees that process is the biogas producer here.
Can I ask you about the pipeline testing requirements? As I understand it, one of their points is that EPA has required testing for components that are not necessarily in whatever an individual pipeline would test for, and that you haven't sufficiently explained why that requirement has been imposed. What's the response to that?
So the regulation does provide, so EPA does provide that pipeline, that RNG producers have to provide testing that demonstrates that RNG can be placed onto a pipeline. There is a specific exception in the regulation itself that's at 40 CFR section 80.135 D5 and D6 Romanet 5. That provision provides that if a RNG producer claims that a pipeline doesn't require testing of other elements, or that a test does not require a pipeline producer to RNG producer to demonstrate that certain elements are required for that pipeline, they can request an alternative testing process.
And that operates as an exception to what's required in 80.155B?
80.155B provides for the specific test that the RNG producer has to provide. They have to run those tests in order to follow those methods to do the tests. So the actual—
So I think their complaint is, for example, if you tell us to, I'm going to mangle this, I'm sure, test for siloxanes, but some pipelines don't require testing for siloxanes based on the type of folks they're working with. Are you saying that they can ask for a waiver that would allow that producer not to test for siloxanes?
Yes, Your Honor.
Okay. See.
And to address some of their concerns regarding why—
Can I ask one other question
Yes, Your
about
Honor.
this? So it initially seemed odd to me that you have a list of things that must be tested for, but not, at least that I could find, standards that they have to meet. Is that because all EPA is doing is comparing these test results to the pipeline requirements that have to be separately reported? What are you comparing the test results to?
The test results are meant to show that, so the RNG producer, when they register with EPA to say, I want to get into the program to generate RINs, they have to provide the pipeline specifications for which they are putting the product onto the pipeline. These regulations, to clarify, and I know this is a long-winded explanation, but in the pathway to which these requirements apply, they apply to RNG producers who generate RINs through uploading onto a commercial pipeline. So when they register to do that, they have to provide EPA with the pipeline specifications. So saying, here's what the pipeline requires. And then when they register, they're telling EPA, not only through the engineering reviews that we require, do we have a facility that's capable of doing this, but we are in fact capable of upgrading biogas into renewable natural gas that can get onto a pipeline. So it's a demonstration at registration to show that the party has a business being in the program.
And when you get the annual testing results, you are measuring that against whatever the pipeline specifications are to double check.
So EPA requires that information. So yes,
Okay.
yeah.
I see.
Right. Thank you very much, Council.
Thank you, Your Honor.
Mr. Ellis, we'll give you 3 minutes.
Thank you, Your Honor. It's just a few points in rebuttal. First, on the statute, I think I heard my friends say that they are not relying on 05 in this rulemaking to confirm that. That's not the rulemaking. I'm not surprised, but I think it's confirmed. So that means they have to rely on
Why couldn't they
02A1.
rely on that since it applies to generation of credits by persons that refine, blend, or import.
So I
How would
understand.
producers fit under there?
So I understand that provision to allow for the creation of the credits that are ultimately, and the creation of the credits, and I don't think I've ever seen an explanation of this, so this is my understanding of it, is it happens when you separate the RIN at the end of the process. And then the generation happens by the RNG producers. That's been, or the renewable fuel producers. That's been the way that they have.
Generation in the statute is by by any person that refines, blends, or imports. They don't mention producers here either.
So I think that the way they have, I'm sort
Your
of.
theory is that they can regulate renewable fuel producers. Your theory is.
Absolutely.
They can regulate under this provision. It
Yes,
does
and
not
that's how
It doesn't list producers, just like 3 doesn't list producers.
but it does allow specifically for the creation of credits for those obligated parties. And I think that the way that they have set up the system from the get-go is that the renewable fuel producer is the one who generates the RIN that's ultimately separated and then regulate that way. If you look at the RFS rule,
Congress
one
lists
rule.
in the statute, regulations of persons that refine, blend, or import. That concludes the authority to regulate producers. Or
No,
at least
so-
if they're part of the generation process.
I think there's an important difference in language in 02A3 and 05. 02A3, you're right, provides for regulations shall contain compliance provisions applicable to the obligated parties, as you noted, Your Honor. 05 says shall provide for the generations of an appropriate amount of credits by a person. They've provided for that appropriation, that generation of credits by this RIN system that allows you to then generate the RIN at the beginning when you produce the renewable fuel.
It says
and
who
then
can generate the RINs. That's what I'm trying to get to.
I'm sorry?
It says who can generate the RINs.
No, it says who can.
Refiners, blends, or imports.
It says who can regulate, who can have the credits, who can generate the credits. I think the credits, you have to generate a RIN and then separate a RIN. And that's the credit that you can then trade. And in fact, you've also then got to show that you.
Statutory language that says anyone or producers, or assures me that producers can generate the RIN in the first place.
So I think 05 is the best I have. The thing I will back you up,
I mentioned producers anywhere.
so if I could add to that point, this is the way they've always done it. And they did it before Congress amended RFS 1 to make RFS 2. They promulgated this system. They announced they're doing it under 05. I'd encourage you to look at the rulemaking for RFS 1. And then Congress amends the statute, including amending 05, and does not say anything about, does not question the process that EPA had just set up under 05 to generate these RINs. I think that is.
They said that they had always been regulating producers, renewable fuel producers under 1. 2A1 or 1A2, sorry, let me get the page. Under 2A1, they'd always been doing it under 1. And Congress didn't change that.
That's not how I read the rulemaking record, Your Honor. I would look at 71 Federal Register 55552 They expressly cite 05 in the very first RFS1 rule when they set up the credit program, and 71 Federal Register 55557 that talks about how the RNG producer is going to have to have the auditing done to show that the requirements are met when they generate the RIN. That's what they did from the outset. That's what Congress ratified. If I could return to a couple other points, Your Honor, I wanted to just point out that 02A1 or A3 rather, you pointed out that it says shall contain applicable to the obligated parties. It goes further than that, tying it back to 02A1. At the end of 02A3, it says you can promulgate these regulations, quote, to ensure that the requirements of this paragraph are met. So that's the way you ensure. 02A3 tells you that's the way EPA is supposed to ensure. I think that implicates this court's discussion in heating, AC, and refrigeration that says to ensure is to make certain, sure, certain, and safe. So Congress tells EPA to ensure. But when all it said was the agency should guarantee that result, the rest of the statute tells them how to ensure. That's what 02A3 does, and we don't think that they can rely on 02A1 in the absence of that to expand their authority. The last thing I'll say on the statute, she said, excuse me, I'm over, so I'll wrap this up. She said, you asked, will it work? It does work. It has worked. It works this way for every other renewable fuel producer. And I don't think they provided any explanation for why they departed to here. If I can make one last point, you asked, Your Honor, about if this was a point in the rulemaking. JA 369, Kinder Morgan raised this point. JA 438, we raised this point that they shouldn't be treating biogas producers differently than the other producers.
Thank you very much, Counsel. The case is.